watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is in re amendments to the Florida Rules of Judicial Administration, etc.
May it please the court, Paul Regensdorf with Holland & Knight in Jacksonville. I come to advance the cause of email service today. I will be the only one in all likelihood presenting an argument to this court, unless there's a question that the court has that one of the other rules committees needs to address. However, I think it needs to be remembered that in presenting this as one guy against this assemblage of talent, I speak for hundreds of lawyers who have prepared this rule and tried it and approve it. So it's just one voice, but it's one voice from a guy who's been in this since the beginning. I think this is an exciting day for the people of Florida and for the courts in Florida and for the lawyers in Florida, because I think this court has the opportunity today to consider and hopefully approve a really significant change and advancement in the practice of law in the state of Florida. I think the other opportunity that you will have within the next few months is when e-filing comes before this court. And I think those two actions, if you find them to be acceptable to the court, really are an exciting change. It is the first.
This, and I appreciate all the work that you have done over the years in technology and also in serving in this, and you've set forth how many rules committees came together. But is it a smart idea to adopt this rule before we adopt the e-filing
Yes.
rule, first of all? So if you want to answer.
Absolutely. In my opinion, the answer to that is absolutely yes. First of all, email service can be implemented with very little, if any, a substantial change in capital expenditures, in training, or in anything else. The benefits
It seems with regard to that, it seems that certainly the public defenders don't agree with that,
Well-
and certainly the small practitioners don't agree with that. So I understand your view. You've been doing this. You've been advocating it. The one thing that concerns me is you got a group of folks that this system depends on to make sure that it works.
No question.
A large segment, the public defenders, and they don't see this through the same prism that you say.
They don't, at least in their initial presentation to the court. The association didn't. If you read that petition, and I know you did, or if that response, you would think that every public defender in the state of Florida has a big cart that the Postal Service gives them, and they put the papers in there, and somebody in a burlap suit rolls it down the hall to the state attorney's office and vice versa. And that may be the case somewhere. But this is not a good fact-finding opportunity. I mean, this isn't where we look into this. But I've made every effort I could to try to find out what is going on in the state of Florida. Are we really causing a problem?
But let's say, because the public defenders in the criminal area is so different than the practice of civil law,
Right.
wouldn't the better idea be to, since we have this bridge period, to exempt the criminal rules and either order that the Public Defenders Association with the state attorneys pick 3 pilot circuits to start attempting e-filing? Because I thought the best argument they have is, say they have volumes of papers, but they're not a lot of them. I mean, volumes in a lot of cases.
A lot of cases.
But then we're still requiring them to paper file the original. So for them, until we have that they e-file, and the judges are sending them orders by email, it's kind of, we are really making something. So what's wrong with,
Right.
and again, because the civil practitioners are certainly in the civil rules, that's a major chunk of what goes on.
No question.
What would be, do you see any downside in that? And then you could see, so you don't, seriously, go to the public defender's office in a couple of places, and let's see, let the Florida Bar help to make this simple and not a burden on anybody. Because as you say, we know, those of us that believe that this is the way to go, and the federal courts have done it, but change is tough.
Sure.
And so what's the what's the downside in doing that?
Respectfully, and I'm not a public defender, and I don't profess to have analyzed it in depth. However, reading their response is very interesting, because they emphasize how their practice is so computer-driven, and they use so many forms and so many fill-in-the-blanks and so many drop-down menus and things. And I read that, and I said, they can say that their practice doesn't work into the computer world, but their own response emphasizes how heavily they are involved in the generation of computer paper, computer documents.
But Mr. Regensdorf, the bottom line is still that they are under the kind of strain that we cannot even, fathom with the budget cuts.
Correct.
And to implement a new system takes time. So again, I'm still not seeing a downside in the suggestion that we exempt them, let them have, pick 3 pilot circuits and start to work on it. And then when we have our oral argument in October, or whenever it's set for e-filing, we then find, we have them give a status report, because they're not saying we're never going to agree to it.
Correct.
They're just saying right now, please don't put it on us yet, and especially if we have to paper file.
Let me just add one point, and I'm not trying to argue with the court. In terms, you mentioned a new system. I mean, respectfully, email service, as it's presently proposed, is not a new system. I think the vast majority of even small practitioners and public defenders, based on my talking to public defenders around the country, around the state, have and use email and computers substantially in their practice, if not exclusively. Not, I mean that they only use them, but they almost all have them and use them, and their offices do. And the thing about email service is that the benefits are so great, and of course I'm not preaching to the choir, I'm preaching to exactly the opposite, because they say, oh, no, it's too much. But the point is, people are going to be reluctant to change. Everyone is. The vast majority of lawyers, I would be reluctant to change if I weren't up here being an advocate.
Well,
I'd like to retire with paper, but the point is, it's not a new system. It's taking email that they use every day and computers that they use to generate the forms that they say they generate every day, and simply not dumping them onto extra paper to send to the state attorney.
But I still didn't hear an answer to the first question, I believe, is why are we doing this at this point before we actually have e-filing? Why not make this a permissive rule for those who want to file by email? Make this a permissive rule until such time as we have e-filing across the state.
Sure. The rule is essentially permissive today. Any lawyers can get together in any case and agree to serve by email and not by paper. So that doesn't change anything. The reason our committee and all of the committees said, let's do it now, is again because the benefits are so great and the change is so small that we don't need to wait for e-filing.
Well, obviously the benefits are great to those who are prepared to do it. But for those who are not, it just is another requirement that they're going to still, in some instances, have to do the paper anyway. And if they have to do the paper and they're not prepared to do the e-filing, emailing, why are we requiring it at this moment?
Okay. There may be some paper still involved in an email service world. I don't doubt that for a moment. The other part of it is that because, in my opinion, the technical change to email service is so relatively small, it's an incremental change. It's using things all lawyers, virtually all lawyers have, that it can be done very quickly. E-filing, and I don't profess to have my finger on the financial pulse of the state of Florida, but I'm relatively close to it. I don't have, if you asked me, Justice Quince, Mr. Regensdorf, when are we going to have e-filing in every court, in every county, in every circuit? It's not going to be this year. It's not going to be next year. It's probably not going to be the year after that. That's right. And there are some reasons to delay email service, but the benefits, respectfully, greatly outweigh that.
I also have some concerns. I mean, I know that it might be a little nitpicky, but often you get emails that go into your junk box. Sure. And emails that you never even end up seeing them because of whatever filters you have on your computers. And so how in the world do we deal with that when you come and tell the court, I filed this, I served this on my opponent on XYZ day, which happens to be the last day you're supposed to serve it, and yet
Here's my response to that, Justice Quince. I'm not shooting in the blind when I say this can happen very easily. There are many, many programs in Florida today using email service, both formally and informally, and I have polled each of them. Again, this is not a fact-finding process, but when the court, when the response comes in and says we can't do this, it's technologically impossible, hypothetically, there could be a problem with spam filters, but I've talked to the First District Court of Appeal, to DOA, to the 11th Circuit in Dade County that has an email service system, to the 15th Judicial Circuit, to the business courts in Tampa and Orlando, to the Manatee County pilot project, to the portal itself.
How about the entire federal court system?
Well,
has there been? And that's a concern that has been raised. That system's been in effect for years.
Years.
Is there anything that there? Have there been problems with it?
I'm not going to. Excuse me.
Go ahead.
I'm not going to suggest to this court that there hasn't been a pleading here and there that went into a spam filter and had to be dug out. I'm not suggesting that at all. Certainly they can be misaddressed and not get there. There are all kinds of problems that could happen, as there are with mail. I mean, the truck could have an accident. It could burn down. People can put the wrong address on it. They can forget to put the stamp on it. There are 1,000 things that can happen to mail. None of those are covered in Rule 1.080. None of them. But yet we live in a paper world, and we all put up with, where the heck is that pleading? It was supposed to come yesterday. It's not here. Oh, they sent it to the wrong place. It happens every single day in the paper world, and we live with it. And I'm not going to tell you that this is going to be a perfect system. But, you know, there's a cliche that I have taken on as a phrase that I use, as with most cliches, too often, and that is, we shouldn't let the perfect be the enemy of the good. And an email system has the benefits for virtually everyone, I suggest.
I wanted to ask you about a benefit that is very important to this court, and I think to courts, which is the number of orders that are sent out every year, and, you know, the requirement of the stamped self-addressed envelopes.
Absolutely.
Our clerk tells us that, of course, we try to send out our orders by email, but because email addresses aren't required, people are saying they don't have it. Will this rule then require every member of the bar to have a primary and secondary email address?
If you appear in court, yes.
Okay, so it would then allow clerks of court, trial judges, to send, instead of the burdensome, the stamped self-addressed envelope system, to send out orders by email.
Absolutely.
Is that I mean, we were going to look again. Is that, because our clerk said that there's a rule that actually says it must be sent by mail. Have you looked at that? Is there a rule that
There's a subdivision for clerks and there's a subdivision for courts, specifically authorizing both to utilize email.
I was curious that the clerks of court, who could be benefited from this, were they part of this process?
Absolutely. The clerks have been involved. They totally agree. They're moving forward. They're trying to drive this train as best they can. It would be nice
to have gotten the comment from them.
They saved, there have been 7...
I mean, in other words, you're saying, the problem what we get when we have these kind of comments is that maybe the overwhelming majority of the lawyers in the state and the judges and the clerks want this, and then we get, and I'm not saying there's a person here or there, but they become, their objections are heard much more loudly. So if the clerks but you can represent that the clerks of court have worked with you on this?
I can, and let me split up what you just said. I think the clerks want to do this in spades, and they are the ones who asked us to put that into the rule. The FACC, and I can't speak for every single clerk, all 67. Now, you said something else that I'm going to take some issue with. I am not representing to this court that the vast majority, or necessarily even the majority of Florida lawyers want email service or want e-filing. I can't say that. This isn't a democracy. What is best for them? We've had discussions in meetings, and you've been there, Justice Periente, where we have suggested to the court that when you're ready to do these things, email service and e-filing, it can't be permissive, because the only thing worse than the paper system we have is the creation of a dual system and requiring people to do both. So when you're ready to do it, and I hope you're ready this afternoon and sign the order at 4 o'clock, but when you're ready to do this, it needs to be done on a mandatory basis. Do I think a vote of the Florida Bar will say we are in favor of that? I don't know.
Well, let me ask you about an issue that the Criminal Procedure Rules Committee brought up, and that was that a lot of times the discovery is very voluminous.
Correct.
And so I don't recall that the committee actually addressed that after the comment came in.
We addressed it in substantial detail, but not in the rule, because discovery is not officially served. The rules regarding discovery is that it's produced, it's made available, inspection is allowed. They may go ahead and
well, often documents are actually sent to the other party.
Absolutely. I mean, in civil cases, I'm required to make them available for inspection and copying. It doesn't say served. It says make them available for inspection and copying, essentially the same as in the criminal practice. So, yes, many of those are served electronically, and I don't know why they're not doing it today. In fact, I know the Orange County public defender and clerks do that. The public defender and state attorney use that all the time for voluminous documents and discovery of all sorts. And there's no reason not to.
They do what? Do they give them discs?
Yeah, they give them discs, or if it's a small amount, they may email them directly, but they exchange electronic data. And
So
that's
there's no
where
requirement now, because it's been a while, that you make copies of your documents to provide to the other side?
there is
in the
no
rules?
requirement that you make paper copies. You make them available for inspection and copying.
So really, the
Could be copying.
so we're not changing anything about how, so documents could be made available either by paper or electronically at the discretion of the producer or with agreement. And this rule doesn't change any of that?
This rule does not address or preclude or require that, because this is an email service, not email sharing. I mean,
Okay, because there was a lawyer who it was sort of a sad situation where they talk about being in the, I forget, it's a registry lawyer or somebody getting a disc and it taking her thousands of hours to figure out what was on the disc.
Right, and according to Ms. Rhodes, I think that was, it's not even allowed under the rules, perhaps not. This is not a funding rule. We don't address the shortfalls that public retained lawyers face in making copies or getting copies. But I think without much question, the system will save a ton of money if this is implemented. Now, in the particular case that Ms. Rhodes had, I'm not sure. But overall, system-wide, this is not really a difficult question from a cost perspective. I candidly think that the closer it gets to pulling the string on something like this, or e-filing, more and more people begin to clench, and that's normal.
And how does this rule deal with pro se individuals?
They are not required to participate. They are allowed to participate when they give the court or the clerk an email address, then they become an email participant. So we felt that this court would not require email service for pro se. So we simply allowed them to join the system.
It's too bad we can't require pro se prisoners to get an email address.
There's no
would really
question
help
that
a lot of us, wouldn't it?
that would save the courts a tremendous
Well, it would
amount
save
of
the
time.
Department of Corrections a tremendous
And it's going to happen someday, but it's not today.
I mean this somewhat, it might sound funny, but the amount of handwritten, documents get lost in the mail, if we could ever get somebody to, with the Department of Corrections, and we've looked into this, but it really is an important part.
Oh, it's a massive problem. And this does not solve that problem, because we can't fund the DOC, and even if we did, we're not requiring pro se's to do anything electronically. So I see my time is done. I would like to reserve some time for rebuttal, depending upon what is said, if that is acceptable to the court. If not, I'll finish and use up my time. But
Why don't you use your time? That's really not the protocol.
okay. Well, there's four things I wanted to touch on about the rule itself. Technologically, I think I've addressed the fact that there's potential issues, but the real world has not demonstrated those. But the four things are, in the rule, email service equals mail service. That gives lawyers 5 additional days. People don't realize that. That is one of the strongest features of this rule. Secondly, we wanted the rule placed, meaning the email service rule, the 2.516 component, placed in one place. This court and the RJA have worked together, I think, in consolidating some of these system-wide. You're smiling. I hope that wasn't about the comment.
No, I was just smiling, Ms. Giddings, as I realize how much work she's done as chair of the
Absolutely. God bless her.
Rules of Judicial Administration.
You, Ms. Giddings.
She's getting to be a member of the court family after being here every day.
I understand. The concept is to place these system-wide rules in one place in the RJA. That's where 2.516 is. Everyone signed on to that at the beginning. That was one of our basic core concepts. It continues to be. I simply would point out that there are 3 places in the juvenile rules where they thought it important enough to put the email service rule back in. It's not really different. It's just they copied it 3 times. When we looked at the service rules, starting with 1.080 and compared them across the 10 sets, they had grown from a simple rule and they had changed and morphed in all different directions, because every rules committee took theirs in a different direction. We think it needs to be in one place. Third, we, in writing this rule, tried to change as little as possible. We anticipated that there would be resistance from lawyers, whomever, perhaps the court, to a change, and so we didn't try to reevaluate every aspect of service. We only tried to change email service. So there are some comments made that address little points about service that were also there under Rule 1.080. We have not tried to address those. That's for another day. We changed email service for the system. And finally, a small point, the probate people who participated very, very actively in this process were quite concerned about service of documents with respect to formal notice or in the manner of formal notice, and we have accepted that out because they are much more in the nature of complaints, if you will. And so, as a result of that, that has been kept out of 2.516A. If there are no further questions, I have exceeded my time. Thank you, Chief Justice. I apologize. If there's no further questions, I would urge on behalf of a whole lot of people that this rule be implemented now. Thank you.
If it pleases the court, my name is Matthew Capstraw. I'm a lawyer. I'm here on behalf of the Family Law Section of the Florida Bar. We wrote and made comment to this rule for many of the differences that we as family law practitioners will go in and have to deal with and change our practice if this e-service is implemented. Counsel is correct that we do email each other, but we also at this time have the choice whether we are going to email each other or not, or what we're choosing to email each other. My colleague will be talking in a moment about the security concerns with email, but specifically within family law, we actually have a mandatory obligation to forward to opposing counsel certain documents under 12.285. These are documents dealing with last 3 years of tax returns. They're documents dealing with all parties' financial accounts, credit cards.
Are those filed with the court?
The actual on the top form is filed with the court. There's a mandatory certificate of compliance with mandatory disclosure that's filed with the court. My interpretation of the rule they're putting forward in conjunction with 285 is that this would require us to mandatorily to transfer these documents via email. To do so, each family law practitioner will have the obligation to have a scanner within their office to convert all of these statements to an electronic format, and therefore to be able to forward them to opposing counsel in that manner. I want to talk a little bit a moment ago when you talked about, I believe it was Justice Quince, with the difference between if this rule is permissive rather than mandatory. In making a mandatory statement, there are times in which I would expect to see that we're going to have hearings coordinated, set a notice of hearing that is going in and mailed to opposing counsel, but we don't have a notice emailed. Is that now notice of hearing that was mailed within a sufficient time, sufficient for a hearing? And I can expect you're going to see certain judges are going to go and move differently, which also segues into the issue that ending with the probate rules. When we received the comments back dealing with the concerns that the committee had with the probate rules, the gentleman that is the chair of the probate rules committee was kind enough to email me. And he was kind enough to email me with the information that these are what our concerns are. This is why we're concerned, because the family law section took to redrafting some areas of the rule. And their concerns dealt with their particular issues of formal service. With our redrafting, we have a simple manner to change our first paragraph to address the probate's concerns. Simply, all we would have to do is change the paragraph first that comes up with the family law section version of the rule, to change it to read all documents and pleadings subsequent to the initial pleading may be served upon each party in accordance with the rule except those that are required, and adding the words or permitted to be served by formal notice or in the manner to be provided by formal notice, in service of formal notice. That last part, formal notice or in the manner provided to serve formal notice, addresses the concern of the committee and fixes that concern. But we added the language required or permitted to be served in the manner of formal notice because in those conversations we learned that there are times in probate in which you may serve or you may use formal service. You have the choice. But under this rule, it says you must mandatorily do it. And the example earlier I gave with a notice of hearing, I don't want a situation where someone can make an argument that, well, I formally served them, and the other side says, well, but you didn't send the email. The rule has to say you sent the email.
Do you believe that your position would be different if, in fact, we had e-filing across the state?
I believe that if we are going, My initial expectation, if you'll notice from the comment of e-filing and what the rule was, are somewhat different. I am a proponent that if we are going to go in and have changes that affect every practicing attorney in the state of Florida, I think that both with e-filing and e-service are going to each be distinct changes. And if we should go in and minimize what we have, I believe that we are going to go in and that there are certain times in which we should be able to serve each other directly, whether it be delivery of discovery, for the example of...
Can I just...
Yes, ma'am.
Go ahead, so, because I see your time's almost up and I
Yeah.
had a question, but
Yeah.
finish Justice Quince's...
So the bottom line is what? That you would have a different position if we had e-filing?
The bottom line is e-filing is as much of a concern as is the transfer of the large amount of documents dealing with the financial and the possible security issues. To go in, I know I'm going over time, apologize to my
You have a
colleagues.
question you want to...
Yeah, I was just, I guess my question, and I always think with family law, this section has been so wonderful in trying to make family law less adversarial. And when I think of something as simple as a notice of hearing, think you get it by email, you know, you have it, you still have that extra 5 days. I'm just having a hard time thinking of how lawyers are going to be litigating something that is designed to give notice.
Right.
If a notice, the email appears immediately, whereas the mail notice may, you know, who knows? And so there, when you get, you know, I think you have some legitimate questions about the issues of the tax returns and,
Right.
you know, and whether those have to be, you know, there's some, I think that Mr. Regensdorf said that the documents may not have to be produced electronically, and that would solve you know, and we can clarify that. That would clarify. But I would just, you know, the family law section has been a wonderful resource for the court, and whatever we do here, I just would urge that you and your colleagues work to sort of make this whole thing less adversarial, and let's see how we can, again, make this work and be less expensive for the litigants by using forms that will probably be less costly in the end. I mean, certainly scanning a document in is better than copying, you know, dozens of documents. So would you promise to work in that spirit?
We certainly agree with that, Your Honor. And to say the example of the notice of hearing may not have been artful, but there was simply to make the point of we have a rule that says you must do it in this way, and the situation in equity, I would suggest that the example I gave, you would go in and say the notice of hearing was fine, it was mailed, they have it in the mail, but now we violated this rule. And that was my only reason. Very quickly, we did some rewording of the rule. We kept their language and their intent, but we did so to make it more direct for pro se's to understand it and make it more direct for pro se. We went in and took out language such as all service shall be by email, except further provided by this rule, to go in and allow the direction, because it's our belief that many times people stop reading, and the easier and more simple we can make the rule, the better. One of the other additions we made was, as we added, as gentlemen spoke about earlier, that pro se's can opt into the system.
You're going to need to wrap it up here. You're
I'm
2.5
trying to
minutes
as quickly
over.
as I can. That they have also have a way, and we included a manner for them to opt out of the system that is controlled and going to the court. And we also provided just simply with the default language to ensure that we have in family law cases that in dealing with children that there are still notice requirements. And I thank you and apologize for going over my time.
Good morning, and may it please the court. My name is Kurt Lee. I'm a board-certified business litigation attorney out of Sarasota, Florida. And while I oppose and file a comment in opposition to the proposed Rule 2.516, the rationale in my comment from a civil practitioner has been, you know, picked up on by Justices Quince and Periente, to the extent that the rules mandate that service be by email, as opposed to simply having it be a permissive alternative, is what makes the rule particularly onerous.
What have
from our
you
perspective.
said you're a business lawyer.
Yes, Your
and
Honor.
I understand that the business courts in Orlando, Miami, Tampa have this as part of their requirement, and also that the federal courts, certainly where there is complex business litigation going on, have done both e-filing and e-service for years.
Absolutely, Your Honor. And indeed, It was, my comment was to the effect that we should wait for e-filing. The PACER system works great. Just filed one yesterday myself, not even through my assistant, and it went to the Middle District. Everything was fine.
I think the problem is this waiting thing, which unfortunately, and I've been involved in this for years, and Mr. Regensdorf and I would have done this 10 years ago if we could have, all of it, is that you've got the clerks of the court who are trying, that if we don't get every lawyer thinking about the whole e-world, you know, and starting to put documents in that format, that when e-filing comes, it's going to be even more dramatic. And so that's the policy reason for not, quote, waiting until there is actual e-filing going on.
And Justice, respectfully, I think the court will get the lawyers thinking if it makes the rule permissive and allows for e-filing. The economics of e-filing for some offices just makes sense. For our office in particular, it would make sense to try to do
e-service.
E-service, I'm sorry. Yes, e-service would make sense because we would save, some pennies in paper, and we wouldn't have to do postage, and it would work, most of the time. But there are those instances, Your Honor, where a particularly difficult opposing counsel who won't confirm receipt of an email or some other difficulty in dealing with another office, you can have a problem.
If you have difficult opponents, and you don't already have them in the paper world?
Well, no, Your Honor, you don't, but there's things you can do with service that help get around that. And for example, in a case we had after we filed the comment, we had to spend, I'll give the Reader's Digest version, just trying to get a document from the city of Palmetto into our office. We had to have our IT person spend 2 hours with their IT person trying to figure out why this email transfer couldn't occur. These are two completely friendly entities trying to share information electronically. After 2 hours, it was determined that it was a firewall, not at our office, but at the city of Palmetto, that the sender was only allowed from the city of Palmetto to send a certain number of emails each day. So it's the cost of that, Your Honor, that we object to as part of this rule change. If it's permissive, then it allows your early adopters, or I guess in some cases late adopters, to go ahead and start doing this. But it also it affords the opportunity to still continue with a system that's not broken.
I thought that what and we're going to have. He said that it's to documents. This was not mandating documents be produced electronically. Does that help your situation? Because those are the documents are the ones that either can be. I've had, somebody tell a manufacturer saying, "Here, go into my, my storeroom and look at 200,000 pages of documents." They're not going to have to put those documents all on a disk and just give it up.
Correct, and he's correct in the sense that the discovery rules don't require a production through electronic means, although my office and other offices, we do take advantage of having things in a searchable PDF format. But the problem, Your Honor, is really for just service of papers, because the way the rule is written, it puts the onus on the sender to confirm that the email is received. A lot of people, have turned off their automatic receipts for email because it helps keep down the amount of junk email that comes through. But what the rule will require is that every time we serve a paper is that me, my assistant, someone from our office will then have to get verification if it doesn't come back electronically that the paper's received.
I didn't read the rule as requiring that. So, and I see Mr. Regensdorf shaking his head no.
Well, it's in their petition, Your Honor, to make clear that the onus is on the sender, and it's also, if I might, in proposed rule section B, subsection D, where in subparagraph 2. It says that if the sender learns that the email did not reach the address, then the sender must immediately send another copy by email.
Well, that's certainly, if you get it back that it didn't reach it, I think that's a different situation.
Where does it say that you have to confirm that the email was received? What specifically? I didn't get the site.
There's no need to confirm it, Your Honor, but if you want it to be effective, then you need to...
I'm missing something here. I thought you were just saying that, and forgive me if I misunderstood, I thought you said that someone who sends serves something by email is required to confirm that it was received. Did you not say that?
I did, Your Honor, and I apologize if I said that by going too far, because I did say that.
Is that correct?
The rule does not require that, Your Honor, but the email to confirm that you've got effective service, I believe the rule requires that you confirm that your email actually got there.
Well,
Because otherwise there's no way to know.
If it comes back, then you know, but if it doesn't come back.
Right, and in that case of the Palmetto that I mentioned with you, Justice, there was no bounce back. It just went into the email abyss.
I'm sorry, forgive me, I'm still not following. You're saying the rule does not specifically require that, but it indirectly requires?
I believe so, Your Honor.
Okay, where does it, just give me the reference to where it indirectly requires it.
Subsection, it's B, capital D.
What's the rule number?
Yeah,
I'm sorry. It's in 2.516. I'm sorry,
yeah, we got a lot of different things here.
No, I just thought that's what we were doing.
2.516?
Yes, Your Honor. B, 1, capital D, sub 2.
Okay, thank you. Appreciate it.
Because, otherwise, if it goes in, if you just send it and you don't get any confirmation that it got there, then you don't know. And it goes back to the inherent unreliability of email. I attached, for example, a comment from The Economist blogger from a couple months ago where he himself noted that emails become more unreliable. Thank you, and I'm sorry for confusing the court, Your Honor.
Thank you.
Please the court, John Eddie Morrison on behalf of the Florida Public Defender Association. The Florida Public Defenders Association does not oppose e-filing. We're wildly looking forward to the day when that happens. What we oppose is the tail wagging the dog. E-service coming before e-filing. That is wildly inefficient for us. It's not that paper is the most inefficient system or that electronics is inefficient. It's both. And
now I think you raise an excellent point, especially with the nature of your practice because of what you've said. So what about your alternative, and I assume you're speaking on behalf of all the public defenders.
Yes, ma'am.
If we exempt the criminal rules, and I guess the juvenile rules do not object because they're not here.
Well, obviously, we handle all the juvenile,
so
or at least
you would want to...
Juvenile delinquency cases we handle. Obviously,
but
the juvenile rules also have dependency,
okay, so you're
and we
doing
don't...
it for juvenile delinquency.
Yes, ma'am.
That we would request that the public defender's office with the state attorneys pick 3 pilot circuits to start the email going, and maybe it's in circuits that are ready to start to accept e-filing, and then you would really have, because we're looking for that, we'd have the best of all worlds. Would that be acceptable?
I think that would be acceptable. What I'm not certain on is whether there is any circuit in the state that is ready to do e-filing in criminal cases. Unfortunately, we are sort of the last house on the block to get most technological advances. I will speak for the Miami-Dade criminal justice system. If you've never practiced in the system, the online docket, it's just a docket, still uses 1983 technology. It's a black screen with green letters that you fill in the little blanks. The young kids who come into our office laugh at it. They have never seen something so archaic. Of course, it was the computers I first saw.
Well, are there any public, because whenever Miami-Dade speaks, we listen. But we always think, well, it's Miami-Dade, it's the third...
it's actually worse in some other places. Some public defender offices do not even have email systems yet, the very small ones.
Okay, but are there any public defender's office where things look a little better, like where... and of course,
we have done as best of an informal survey as we can do. There are a couple that say, essentially, we're not doing anything now, but we're trying to get ready. The system is trying to get ready.
How many, in a criminal case like that you handle, how many pieces, you're saying it's more the volume, because in a particular case, how many pieces of paper are actually served on the state attorney's office or vice versa?
Most criminal files, by the time the case is done, will be about an inch.
I had a partner in practice my files would be like this, and his with the big retainer would be like.
Yes. The volume is not the volume of documents in a case. It is the 800,000 cases per year. That's just the public defenders. The state attorneys probably have over 1 million.
But you don't have to, you deliver them, you don't spend any money in actually getting them over to the state attorney's office?
There's a little bit, but the cost per unit, once we have to produce a paper original, it costs almost nothing in addition to print off another copy and have our courier take it over.
Okay,
and
so you actually
despite
are
Mr. Ragantor's,
I just want to make sure, you're actually printing things, you're not handwriting these.
Oh, yes.
Okay,
We have managed to do that, and gratefully. I mean, that's, we survive, our budgets survive completely.
So the beauty really would be, you fill this form out on the computer. If you can, with a click of the button, send it to the court and send it to the state attorney's office, you really have actually saved yourself.
That is what we need, and we need it to come together like that.
Well, can't we work on that, Mr. Regensdorf? I mean, seriously, I'm serious about this, because we do have some, I mean, there's an issue of what comes first, and maybe we do, we try to get e-filing in, some of these circuits and get this solved, because I hear you.
Please, when we're going to invest in the computer systems to do this, we would like to invest the taxpayers' dollars only once.
Are these, as you're doing your normal day-to-day practice, as I understand it, is that your public defender may walk in, there's going to be a mountain of files each day that they need to work with in the courtroom, and that they don't have that office time as many civil practitioners would have to sit in their office with their computers. So we're also, do these service of things occur right within in the courtroom, don't they?
Oh, yes, Your Honor, all the time.
So, we're going to have to look at that as well, the capacity of the equipment within courtrooms so that you can do what you need to do, because you can't go back, can't spend all day on 800 files and then go back and do it again.
Essentially, yes. It's not quite 800, but it is not an exaggeration to say that our attorneys will have 20 cases set for trial on a Monday morning.
Yeah.
And that's typical, and that's a felony case. That's not misdemeanors, where it's much higher. It seems so simple. You print off a document, why can't you just email it to the state? And it is in a document. It's when you start thinking about the total volume and the batching. We just have to do this by huge batches, and that requires big computer systems, and we would ask that this court only make the taxpayers do this once.
So you're, in practice, you hand deliver many documents?
Absolutely. It's very common that you've got your documents, you just hand them to the state attorney in court. A lot of times my certificate of service reads to the state attorney present in court this second day of June.
And this rule would eliminate the possibility for any hand delivery of documents?
It would, no in terms of discovery, because Mr. Regensdorf is correct that discovery does not have to be served. But it would make service of document, doing what is commonly done, just walking over, you walk into court, you got 3 copies of it. You hand one to the clerk, one to the judge, and one to your opposing counsel. And that makes that inappropriate service, because you have to now go back and get that electronically served, because it's service is mandatory.
A motion you're talking about.
A motion to suppress, a witness list, a
memo of law, or whatever.
A memo of law,
anything that's required to be served.
A rule to show cause to get the police officer to finally come in for the deposition. These are very short little documents. These are 1-pagers if we can possibly help it, because if there's 2 pages, they tend to lose the second page. Sorry, I don't mean to joke.
No, we don't mean to. We're just thinking about in death. Of course, in death cases, we see more than one.
That was one thing I wanted to caution this court. When this court sees criminal cases, you usually see death cases because of the unique jurisdiction of this court. And those are a horse of an entirely different color. Those look much more like civil litigation.
Has anyone looked at from the perspective, and this goes back into doing the service before we get to the e-filing portals and all that, as to whether what's happening could be could be forcing folks to buy equipment and capital outlays that may not be compatible with whatever this portal thing is. I don't know. I mean, is that an issue or is it not?
Yes,
Is it totally
no,
not an
that
issue?
is a big concern. I believe that if we will have to set up computer systems to be able to batch and appropriately distribute and appropriately receive emails from the state. That, whatever that system that would be created under this rule, under the mandatory rule currently proposed, it would be a sheer miracle if that system could then dovetail into whatever e-filing
Well,
system.
no, because the e-filing is just, it's a website. I mean, you just, I think that if you talk to your comrades in the Federal Public Defender's Office, who I know have much less work, you can at least see what it's looking like. And
Like I say, the whole system, once we have e-filing, it makes sense to spend the taxpayers' money to create the whole system, the whole service, as Justice Periante so elegantly said. That is our dream. You create a document, you push a button, it goes to the clerk, it goes to the state. It rarely happens, but occasionally you have other co-defendants counsel. That is well worth the investment, we believe. What is not worth the investment is creating that system once for the service and then having to recreate it when we get e-filing. And we don't know when that works. I am well over my time. Is there any other questions I can address from the court? Thank you so much for your indulgence.
May it please the court, I'm Lynn Rhodes. I'm a sole practitioner in Bartow, Florida, and I actually am here to ask for an exception to the proposed rule on behalf of my indigent clients. I am a general practitioner and I take court-appointed cases in dependency, both termination of parental rights and regular dependency cases, and I also take conflict cases from the Public Defender's Office, so I also do criminal cases. I also practice in the federal court in that I take simple bankruptcy cases. So I'm familiar with what's going on in the federal court in some manner, but I would like you to look at my practice from the point of view of my clients. I have indigent clients that I have to provide documents for. It's not unusual for me to get a case plan from DCF on the internet that could be 48 pages. I have to print that out for my client. We have to go over it. After practicing about 2 years.
Well, if you got that DCF document in a document like this, wouldn't you have to copy it and give a copy of it to your client anyway? I'm just trying to see what you would have to do differently than if you got a paper copy of it.
Well, when I get a paper copy of it, I can give my client a paper copy.
But you wouldn't keep a copy for yourself?
If I'm getting it electronically, I can keep it on my computer. But what I have discovered with my clients is that many of them cannot read, or if they can read, they don't understand what they have.
well, then
read.
they're not going to be able to read the case. I mean, your comment was read it and very well taken. DCF right now is making their case plans available on the internet. Is that what you're saying?
No, they're not. Well, they are on the internet through the clerk's office, but it took me several months to even get a password to have that available to myself.
But that's outside, in other words, there are some things as we move to the electronic age, and whether DCF is all electronic, I don't know, that we can't control directly. It sounds like, just like we mentioned, the First District, the workers' comp has moved solely electronically. And I don't know, I would assume if there are indigent, clients, it would be in the workers' compensation area because, most of them are out of work. And it seems to be working. Now, it may be a whole different practice, but I'm concerned that we take one thing in isolation, which doesn't seem to be either, if it's discovery or a case plan, I guess the question is that filed with the court? Is it, right now, it would have to be filed in a paper copy, right? I'm just not seeing where, if your client can't read, I don't know how does any of this really make a difference?
Well, what makes a difference is that if I have a hard copy that I can go over with my client, that I can highlight certain terms, that I can explain those terms, that I can then give them the copy that we've made notes on, that they may have some better understanding, that they may have a person at home who can also help them understand their case plan, they have a much better chance of actually succeeding. Whereas
But couldn't you want to document, wouldn't you, if you got that electronically, be able to actually highlight it, maybe, make it a little more, edit it so it's more easy to understand and then print it out?
And then print it out. But when I'm printing out 50 pages, I don't get reimbursed for any of that. So what's happening is that...
But don't you have to give them a copy of 50 pages now if they send you a hard copy?
I give them any copy that I have, and I do have to print out a copy, and there is no way for me to get reimbursed in that.
Well, just following up on that, I'm having real trouble understanding your basic point here. Because if you get a copy, a paper copy, and you have to duplicate that to give a copy to your client, I don't understand how this is imposing anything different, any additional cost burden on you than you would already have in connection with copying. What am I missing?
All right, well, it used to be that I got reimbursed for copies, but now I'm not. Okay.
If you would answer my question.
All right.
How is this imposing a higher cost burden on you that's different than what you incur now, assuming that you don't give your only copy of a document to the client and then not have one for your file?
I do give my only copy to my client.
Okay. Well,
and then if I get a copy from DCF, I give that copy to my client. And I do have access now, after working about 6 months with the clerk, to get access to view that same document on the clerk's website. On the clerk's website, I cannot use a new version of the internet search engine. I have to go back and use an internet search engine that's about 5 years old in order to access the clerk's website. But I do have electronic access to the hard copy that I've given to my client.
So what you're telling me, you wouldn't give the sole copy, paper copy, to your client if you did not have electronic access to the information?
Right.
Okay.
But when DCF is refusing to, and now also I have a letter from Jerry Hill, our local state attorney, who says that he's going completely paperless, and we will not be expected to have any papers served on us, and that we will be required to have our email listed with him. Now, I sent an email to him in response objecting to the fact that that is not legal service at this time, but he has not responded to me on that either. So people are, the state attorney in particular here has notified us that he doesn't care what valid service is. He's going to serve everything via email, e-filing, whatever it is. So we're left with no, if the state attorney is taking this into his own hands, DCF, the only way that...
But you're really giving us, you're giving us the real world.
Right.
But the issue of who stopped paying, whether DCF has to give you a copy of a case plan, is whether people like yourself who are essential to the system are getting less than they should. Unfortunately, that's not, we're now talking anecdotally, and it's always hard in these oral arguments, again, we appreciate your comments, but I don't know that we're going to solve Jerry Hill here, except that if we exempt out criminal, Jerry Hill will have to continue to do what the rule requires.
Well, Your Honor, thank you, and probably that helped to refocus my argument that what I'm asking is an exception in the proposed rule for indigent clients so that we can actually get hard copies for our indigent clients, and also that our indigent clients then are not required. I mean, I could tell my indigent clients, no, I'm not printing anything out for you. You can go to the courthouse and look up your documents if you need to. You can pay 20 cents in the law library to print out your documents. But I will be glad to go over them with you if you come and sit next to me and look at them on my computer. So it is true that I am giving you an argument from the real world. And I'm also speaking on behalf of all of the indigent people in Florida who don't even know that they have this issue, who don't know what I know, that I hear attorneys saying, oh, I'm not going to get paid for representing them anyway, so I'll show up until a disposition in a DCF case, and I won't bother.
In terms of who you're speaking for, we have legal services all throughout the state. They actually came in on an issue yesterday, and I don't recall seeing any objection from them. Bill Booth, who's chair of the Juvenile Rules Procedure Committee, is with Legal Aid in Palm Beach County. So it's hard to, we're trying to see what's going to be best for in the long run, and I appreciate what you're bringing to our attention, but it's hard to really say that you're speaking for everybody when all those significant organizations never filed an objection.
Well, Your Honor, the significant organizations do have funding from different sources than I do. My only funding when I represent an indigent person is from the Justice Administrative Committee. And when I sign a contract, I sign it voluntarily, but I have no ability to negotiate any of the terms of that contract.
So they're the ones we ought to be dealing with, is that correct? It's to say that they ought to reimburse you for copying costs?
Well, and Your Honor, actually their mandate comes from the legislature. And so I just want to let you be aware that there are issues out there that are causing real problems in the trenches. When we say, okay, everybody can have e-filing, everybody has a computer, everybody has access to the internet, it's no problem for people to go and view their case online, when it is. When I have clients that within 15 miles of the courthouse, it takes them 3 hours by bus to get there. So it's not like, well, no, this is a simple thing that people can just show up and take care of their cases. When they have real life problems, when they're facing losing their children, when they're facing being incarcerated, and when I have to, how will I go to the jail to talk about their case if that's all I have is a computer and I can't get the internet down in the bowels of the jail? And
I hope after this oral argument, you and Mr. Regensdorf can sit down and actually talk about some of these real life problems and see if he and Ms. Giddings can't really say, you got the, because I think you've brought up another important perspective, and I thank you for that.
Okay, and thank you. I see I've gone over my time, and thank you.
We thank you. We thank all of you very much for your comments. Appreciate your participation. The court will now proceed to the second case on today's docket, Douglas versus the State of Florida.
I knew that guy in the back looked familiar. We'll see.
Counsel may proceed.
May it please the court. Represent Douglas. Mr. Douglas was denied a reliable penalty phase proceeding because of his counsel's ineffective performance in trying to investigate or lack of investigation as to mental health mitigation.
I think that it appears that the trial court order either figured that because of this, the fact that the counsel didn't have documents, that he was going to go right to prejudice. So I'm going to right now help you in this regard. It seems to me, and that there is deficiency in not following up after Dr. Kropp said they needed records and all of this. I think what you ought to devote your time to is the prejudice component, because that's what the judge ultimately decided, is that if the mental health that you had presented at the evidentiary hearing had been presented, presumably I guess you would have also presented the lay witnesses, that the jury would just have heard, this is a dangerous, bad guy, and it would not have, you know, that it doesn't, that mental health, just because you now have somebody that will say something, doesn't undermine confidence in the outcome of the penalty phase. So could you address all of that?
I was hoping you would say that, Your Honor. I would like to start with the presentation that was done in the penalty phase. And what counsel did is they proceeded with the theory of the good guy defense. And to be as candid as possible, the good guy defense wasn't supported by the evidence at the trial. One of the mitigating factors they actually asked for, non-statutory, was that he was kind to women. As this court understands, this was a rape murder case with a HAC aggravating factor.
Would you go into some of the specifics, though, rather than just the overview, talky-talk kind of stuff? Am I correct? Looking at the briefs and the part of the record I've looked at so far, no school records were obtained for the trial.
That's absolutely correct,
Okay.
Judge.
What, as an officer of the court, what do you see in those school records? I know it appears to me that there was an ESE component to this.
Yes, sir.
And the individual was in the 7th grade 3 times.
He actually flunked 5 times.
5, okay.
Not in the seventh
Is there a double-edged sword in the school records? Because I'm going to go look at them. But is there something that hurts him from those school records?
Well, first of all...
And if so, what is it?
Yes. In every death penalty case, there's going to be something that hurts the individual on first-degree murder. In Sears v. Upton in the United States Supreme Court, they said that, you know, prejudice can still be found if there is evidence of negative information. However, competent counsel has a duty to turn that negative into positive information.
I understand that. I ask a very specific question.
The answer
What's in the records?
At the age of 10, he had an IQ of 75. He was seen by school psychologists twice, at the age of 8 and the age of 10. He was seen, and it correlates when abuse was going on in the family, when his sister was being sexually abused and Mr. Douglas was being physically abused. There was testimony in the penalty phase that Mr. Douglas, when he was in the womb, his mother was punched in the stomach by his father. His father eventually left, but these correlate together with the abuse and his school records. What happened was he was having behavioral problems in school in the 8th grade.
How bad were those? I mean, is this something that shows a sociopath and that kind of thing?
Yeah, the psychologists were actually, their findings stated that he was having cognitive deficiencies, he was having problems in long-term memory, he was having problems in forming peer relationships, he was having anxiety disorders, he was having poor self-doubt. I mean, there was a wide array. This was a screwed-up kid in 8 and 10 years old, and so what they did is they put him in the special educational program like Your Honor talked about for essentially his entire academic career from 1985 to 1991.
But this murder occurred when he was 37. So, but I think what Justice Lewis is asking you was so that you put on the school records, that's what you would do in a new penalty phase. How would that, and you would establish it as 75 IQ and he had learning disabilities. Now let's get to how this murder has a very significant HAC and a very significant sexual battery of a 16 or 15-year-old by a 37-year-old. How does this all, you know, what you would have done with the school records play into any of that?
Well, there's more than just the school records that were not discovered by counsel. The jury, by the way, did not find premeditated murder in this case. For one reason or another, it was a felony murder case. There was a special verdict form where they did not check premeditated murder. So without speculating, there was something there that they found him not completely culpable for this crime. What needed to be done was there needed to be an explanation of why somebody could commit this heinous crime, because, I mean, it was heinous. And the nexus of him going at the age of 8, when somebody's not going to malinger when they're 8 years old, and when a child's having these problems at 8, you know there's something going on, to where the doctors have established that he has some kind of organic brain damage. There needs to be a nexus between what happens in the school, and then when he is in the school and he's having these feelings of self-doubt and anxiety, he turns to drugs and alcohol, which was, of course, not discovered by counsel or either ignored. They didn't have any records. But what he was doing...
is that in the school record?
It was testified to by the experts at the evidence hearing, Your Honor. He was drinking a pint of Canadian Mist followed by marijuana and doing an 8-ball of cocaine a day and a half. And what the experts said...
Around the time of the murder?
Throughout when he was almost 13 to the murder, he was a
For
consistent...
24 years.
He was substance abuse for a very long time. Actually, in the penalty phase, in which, in my opinion, this should have led counsel to do more investigation, his mother mentions that he was being a truant in school, which is kind of contrary to the facts, because when he dropped out in his last term at 7th grade, he had perfect attendance. He was selling drugs on the street and using drugs, and his mom's testifying this in the penalty phase.
Now, his self-reported history included a rape charge that was dropped, 2 domestic violence convictions, a drive-by shooting, and drug-related charges. Is that, you feel comfortable that you realize that would come in a new penalty phase?
Yes.
Okay. Crop, so you put on now, other than the school records showed deficiencies in his IQ, were there, and I don't remember seeing it, were there any other records, mental health records, hospitalizations that you've discovered that would be particularly powerful?
Unfortunately, Your Honor, I think I need to mention this. We were not evidentiary hearing collateral counsel. We
Well,
took
then
over.
you're stuck with, did they find any other records?
I do not believe they did. What?
Well, you would know. You've reviewed the record. Was anything
No.
else put into evidence?
The school records were put into evidence, and the doctor's testimonies and Dr. Kropp's deposition was put into evidence.
And Dr. Kropp, who had asked for the school records and wanted to interview, said that he suffered from a frontal lobe impairment that would typically be resultant of some type of organic brain damage. He was unable to determine Douglas had any brain damage. He said what he would have diagnosed Douglas with is some type of personality disorder with antisocial features, and there would probably be psychopathic traits based on an elevated impulse control. He couldn't use the word extreme because that's a question of fact. He said he wasn't mentally retarded, didn't suffer from any major mental illness, and his current results would be consistent with those that he would have obtained. I'm not really, I buy the fact that these defense lawyers dropped the ball in looking into mental health and not getting the school records and giving those to Dr. Kropp. So, and I think sort of the trial judge did too. I'm not seeing, and Dr. Kropp, we had him in a case yesterday, I'm not seeing that as particularly explaining this rape murder case, HAC. Are you? Am I missing something in what I just said about the highlights of Dr. Kropp's testimony?
Dr. Kropp did say that. He also said that this organic brain impairment, brain damage, also explains why Mr. Douglas is impulsive and he has a lack of motivation.
But, somebody can throw out, they have a type of organic brain damage, but there wasn't a PET scan. There's not. Where does he get it from? Where's his diagnosis coming from?
He did a multitude of tests for this evidentiary hearing.
But they're not, they didn't show the multitude of tests. Typically, if they're going to show, if you're a neuropsychologist, they're going to have something that will then show frontal lobe impairment. I'm not, he had an elevated score on the MMPI. So it's soft mental, I guess what I see with Dr. Kropp is that I'd consider it to be kind of soft mental health that should have been pursued, but then maybe a reasonable lawyer might have made a decision. This is really not going to explain what happened here to a 37-year-old guy, and we're going to have a host of bad stuff coming in. So then you had one other expert that testified, right?
Dr. Miller, Justice.
And tell me the highlights of what he testified. He began his career as a drug salesman, got in trouble for sale or possession of drugs. So we've got a guy that's not just a drug user, but was a seller of drugs, right?
Correct.
Okay. He thought he had intermittent violent behavior during his entire life. So let's see, and he would characterize defendant as a dangerous man. His pattern of violence, meaning that he was prone to react excessively and violently. And he went on with that. And so that's but he doesn't really attribute that to any organic, anything going on other than he just was a bad kid during his whole life. He got angry, he was a sociopath. How is that going to help you in a retrial?
Judge, all this can be correlated back to his childhood. I mean,
Well, you could, and that was what, did Dr. Miller say this was a result of what traumatic event in his childhood? Being exposed to domestic violence?
His sister was being sexually abused. He was the victim of violence, and what happened is when the father was finally kicked out of the house, the sister and the mother got treatment. And instead of getting treatment, Mr. Douglas turned to drugs and alcohol, and it was correlating with the school. And because of his depression, because of the lack of his treatment, because of the frontal lobe disorders, because of his low IQ, because of the deficiencies in his reasoning and judgment skills, this all compiled to create what happened here, and the jury needed an explanation. That's what Dr. Miller talked about.
Well, I think you've given it a wonderful package that I didn't really see Dr. Miller giving it, in that way, and really with a lot of holes in it. Can you point to where, if I'm going to look at Dr. Miller's testimony again, where that explanation that you just gave, where he tied in lower IQ, frontal lobe impairment, exposed to violence, being a reason that this dangerous man had a lifelong history of violent activity?
Judge, I'll have to, if the court requests, I'll have to brief the court. I don't have the cite in front of me, but
Okay.
what he said is a combination of his deficits, his environment, his neurological impairments, that, quote, these are the dynamics that, according to Dr. Miller, make the crime understandable to the jury. So
Okay, I guess what I would ask you is the judge summarized Dr. Miller's opinion in his trial court order. Is there anything incorrect about the trial judge's summary of Dr. Miller's opinion?
I think he didn't take the summary in the totality of circumstances. He didn't include various records in that determination of
Now,
prejudice.
again, back to the various records. We got the school records. You dropped out in 7th grade. What else?
Other than the school records, or what's inside the school records, Justice?
Well, I guess just the school, you're saying the school records up through 7th grade would show all of what Dr. Miller needed to diagnose this?
Their diagnosis is, in the present time, reflect what was happening 20-some years ago with Mr. Douglas when he was a child in school. They were having he was having behavioral problems. He was acting out. He was trying. He was actually going to classes, but there was something functionally wrong with his brain, which Dr. Kropp and Dr. Miller found through neurological tests. Well,
I just think that's a gross overstatement of what they said, and that's my problem, is that in terms of whether this is the kind of, again, you've raised some serious questions, whether this is the type of thing that does undermine our confidence in the outcome of this, but we really then need to rely heavily on how strong these statutory mitigators would be, because that's really what you'd need to have to overcome the death penalty. Did Dr. Miller testify that the statutory mitigators were met?
He testified that the extreme emotional disturbance statutory mitigator applied. Dr. Kropp did not want to make that assessment because he thought that was a legal term for the jury to make. He did say that he believed it was a severe emotional disturbance, and Dr. Kropp also said that his capacity to conform his conduct to the requirements of the law was diminished, but not to the point of meeting the statutory mitigator. And now, along with those two mitigators, you also have, in my opinion, several very strong others, not statutory but non-statutory mitigators, dealing with his impulsivity, his lack of motivation because of his organic brain problem and his low IQ. And the state, I have to mention this because I know the justices will talk about this, the state in their closing completely diminished the defense's theory of the case, calling Mr. Douglas a smart guy who had all the tools for success. And in reality, that was completely
But then what your
true.
theme would be, he's a dangerous guy that had went through most of his life being dangerous and committing violent things. It's...
My theme would be Mr. Douglas might not be the most likable guy to the jury, but you can explain why he did these things because of a lack of treatment and his deficiencies led to this thing. And with treatment, as Dr. Miller said, this individual probably could have at least done something with his life, hopefully not committed this murder.
What's in the records with regard to employment? I mean, you're painting a picture from 7th grade to 37 as being a vacuum. What other records are there within that interim period? Employment, whatever?
There was 12 witnesses called the penalty phase, and they testified to a sparse employment history. We do not have any employment records.
No records, no nothing. Okay. I know you
sorry,
can't. No, don't be sorry. I'm trying to understand what else is there. I do know that. I mean, the lay testimony's there, but no other documentation, no hospitalizations, nothing at all.
Not that was provided in the trial court at this time of the evidentiary hearing. I cannot speak for it now. I would love to go back but
Counsel, you are now down to a total of about 3 minutes.
May I save the rest for rebuttal?
Certainly may.
I appreciate that.
May it please the court. Meredith Carbulla, Assistant Attorney General, Counsel for the Appellee. Justice Periente, 37-year-old and 16-year-old is in the next case, in the Parton case.
Sorry.
This is Mr. Douglas was 25 years old and 25 years and 6 months old at the time of the murder.
How about his victim?
18 years old.
Sorry about that.
And you'll hear from Ms. Blanco shortly on the 37-16 case. But what I would like to start out with is that the collateral court clearly focused on the prejudice prong.
And I know they did. Here is let's go back to, these are the parts that really concern me. The defense lawyer said that she would be shocked to think he had an IQ of 75. Now, he has an IQ of 75. The fact that the judge said that the dropping out of school, or the defense or the state said, well, he dropped out of school, it was sort of his own choosing and he could have had the tools to make it when he had these learning disabilities, an IQ of 75, that very factor seems to me to be called into question. Now, do you agree that those findings and that kind of approach does color then what the jury heard and what the judge considered?
Two things in answer to that, Your Honor. First of all, both Mr. Eller, who had 20 years experience as a criminal defense lawyer, and Ms. Hepler, who had 15 years as a criminal defense lawyer, perceived him as an intelligent, engaging client. Now, how does that work with the 75? The people who knew him best, including his stepfather, his uncle, perceived that he was of smart or of average intelligence. Now, how do you square that? Because as one of the witnesses talked about, is there's different kinds of smart. There's book smart and there's common sense and street smart. And Mr. Douglas was someone, and he had 4 children from 4 different mothers.
Maybe that's why I thought he was 37.
Maybe. But the people who knew him best perceived him as intelligent, or at least of average intelligent. One, I think Uncle said he didn't think he was as quick as his other siblings, but as for the most part, people who knew him testified that he was intelligent. His lawyers testified they found him to be an intelligent and engaging client. So I think what you have to look at is that maybe he's not book smart, but of course his school records did indicate that he was engaging in inappropriate behaviors. But he's the kind of guy who impresses people as being smart and engaging from the people who knew him best. And I think you have to consider that when you consider the IQ. And I do want to talk about it, and I know...
Don't you though, no, it seems to me is that in reading the cases, and particularly the U.S. Supreme Court cases, that they have emphasized over and over about presenting a picture of this individual and that the defense should do that. And I must tell you, this is, I think, maybe the first time. If nothing had shown up in the school records, we wouldn't even be here maybe today. But something does show up in those school records, and that's the ESE designation and can't get out of the 7th grade. And then the state making the argument that here's this bright and brilliant guy that made all these decisions, when maybe at least it's a fact question for the jury to consider. Now, I don't know whether we carried the day or not, but that's not why we're here. Is it absolutely certain one way or the other? But
Justice
again,
Lewis?
aren't they
I'm sorry.
entitled, I mean, isn't a jury, or aren't lawyers required to give information that's available, which that was, for a jury to do this evaluation to know the whole person?
Well, first of all, if you look at the closing argument, Justice Periente, this is your closing argument. There's no emotional appeals. There's no same mercy. It's to the facts. And the defense counsel said one thing.
Those facts are under my,
People said,
respectfully, for a lawyer to stand and argue that this is a bright and brilliant guy and he did this volition of a total volition, he just ran out of school, paints the picture of somebody quite different than an ESE student who's struggling in school. You can't accept that?
Justice Lewis, if you look at the closing argument, there was one comment that people said he's smart. That was it.
I thought that there were several that I read through it's not just one.
The prosecutor did talk about his employment record, that one of the things that the witnesses said was that he worked sporadically, and in their opinion, he could work. In fact, Matthew McKeever talked about, and that's his stepfather, has known him for 12 years, talked about how he was a good worker and that he talked to one of his employers, and the employer said that he was very good at running the tow more and intended to teach him more. And others talked about his sporadic employment. So I think it is a somewhat of an overstatement to say that the prosecutor was hammering on how smart this guy and how volitional it was.
But the prosecutor did, in fact, make some statement to say that there was nothing mental or physical that would explain this defendant, that there was nothing wrong with him mentally or physically.
Well,
didn't the prosecutor make some statement to that effect?
The witnesses testified that they knew of no mental or physical disability that was affecting him, and that was family members and friends who knew him again and lived with him.
In the sentencing order. Go ahead.
One of the things that really bothers me about this case, I'm not sure where it gets us, but we have two lawyers. Both of them testified at this evidentiary hearing. None of them have any recollection. None of them can recall what they did. And, we got a whole series of everybody's got a missing file. I can't remember this. I don't recall that. But we do know that there seems to be, anyway, that nothing was done after Dr. Kropp asked them to get background records, prison records, any kind of information. Let's have another evaluation of this guy to see if we can put together any kind of a mitigating circumstance. And yet, there's nothing in this record that shows us that the defense attorneys followed through with that.
Your Honor, I agree. What happened is, in this case, is that trial counsel turned their original file over to collateral counsel. In it was a confidential psychological file and a correspondence file, which Mr. Eller testified is that's where he would have placed his notes about his conversations with Dr. Kropp. When it returned to him for review before the evidentiary hearing, both his confidential psychiatric file and his correspondence file was missing. You have to understand these are criminal lawyers. They have thousands of defendants. But Your Honor, what I'm saying is and the collateral court recognized that this lack of memory precluded him. Well, he decided that this lack of memory on the part of counsel, although he thinks it was a reasonable strategy.
But how could it be a reasonable strategy if we have no idea if the defense attorneys had this information? You have to have the information to have a strategy, it seems to me. You would have to have the information about this defendant's childhood, his low IQ, his not being able to finish school, and then juxtapose that with this other information that his family was going to give and make a decision. How in the world could they make a decision if they don't have the information?
Agreed. And one thing we know is that the mom testified about his reading deficiencies. He's being in the special education program. She talked about the Reading Plus, I think.
So wouldn't that be a trigger to try to follow up and see if there's something there?
Mr. Eller testified that when he reviewed Dr. Kropp's report, and he believes he spoke with him on the phone, that he received information that was antisocial personality in the mix, and he decided to go another way.
Was that really in was that in Dr. Kropp's report?
No, it was a request for information, but Dr. Kropp at the evidentiary hearing said his impression was antisocial personality traits, some sort of personality disorder. He did not diagnose him because he was not asked to diagnose him, but he would diagnose him with some sort of personality disorder with antisocial personality traits. Now, it's reasonable to think that that's where counsel got it. And once he heard antisocial, Mr. Eller decided he's going to go another way.
But I think we really, in this case, you're going to lose your argument if you focus on making a reasonable strategic decision.
I'm trying to get off it just okay. I am trying to if you will allow me to talk about the prejudice prong. And
let's go directly to the prejudice.
Thank you, Your Honor.
And as I understand the law from the United States Supreme Court, the mitigation that one may present in talking about the prejudice, how was it harmed, it does not have to have some type of explanation for the direct link to why the murder occurred. It is to present a picture for the final sentencing of who this individual is. It may or may not tie directly in. You know what I'm saying? I mean,
absolutely, and I agree. But of course, whether something has got a nexus to the murder, of course, is probably relevant to weight. But of course, we all know it doesn't have to do with the murder. But I think it's really critical to look at, especially Dr. Miller's testimony. Dr. Miller talked about how that Mr. Douglas's, tendency to overreact is such that rather than extending his middle finger to a person who cuts him off in traffic, he'll get out. He's the type of person who'll get out and shoot the car up. Dr. Miller described, when talking about his psychological profile, that at one point, which was illustrative, Douglas pulled a gun on one of the four mothers of his children because he perceived he was nagging him and was going to shoot him but for the intervention of his brother-in-law.
Now let's analyze that. I mean, and that, you say, comes into evidence if you bring up anything about his school records?
No, I'm saying, well, I think the school records did indicate behavioral, but that's not the claim, that they should have just introduced the school records. The claim is they should have presented Dr. Kropp or Dr. Miller, and had that come out. And I think if they had the records, I mean, again, it's if Dr. Kropp, he said, give me some more records. Exactly, but again, and I don't want to get back onto the deficient performance problem, but what I'm saying is that Mr. Eller said he received information of antisocial, he decided to go another way, and I think.
But you're saying, but once Dr. Kropp and Miller had the school records, their testimony, just because I think this is, to me, it's important that I don't see how that testimony is helpful, and it's a friendly question to you, but I mean, explain what Dr. Miller actually said once he had the school records, once he did the testing. What did he diagnose Mr. Douglas as? What was his mental illness? What was his diagnosis?
No mental illness, not mentally retarded. And Dr. Miller really didn't diagnose him, but he agreed that he would probably have some sort of personality disorder. And he also talked about his antisocial traits. But also, even Dr. Kropp, testified that he administered an MMPI and that Douglas showed an elevated score on the psychopathic deviant scale. That would have come out. Now, Dr. Miller is really interesting because apparently there are some other...
Would that have allowed these other events that you're talking about to come into evidence if that's pursued?
Absolutely. Absolutely.
Because that's how, I mean, in other words, you diagnose somebody as being a psychopath, not based on just the crime, but whatever he's done during his life.
Exactly, and that's why that's why it's relevant and admissible, because Dr. Miller would have described these things. One of the also things about the school records is Dr. Miller also had some information about some of the education programs that Douglas went into as a teen. He described that Douglas had been enrolled in the Jacksonville Marine Institute, JMI. You'll see it in the records, JMI, Jacksonville Marine Institute, which is a school for troubled kids. Dr. Miller testified, and this would come out if school records were introduced, because Dr. Miller said that Douglas failed in that program, not because he has an IQ of 75, but because of his continued behavior problems, attitudes of indifference, and disrespect for the law. Now, that's part and parcel of his school records, which, of course, were not introduced into the evidentiary hearing. So, and that is on page 449 of the post-conviction record. So Dr. Miller evaluated at least his education and said, JMI is an excellent program. Dr. Miller went out of his way to say it's an excellent program.
Well, I had
and he
asked that
failed.
question before about other documents. Are there others in addition to the Jacksonville Marine?
I don't know how Dr. Miller got that information.
Okay.
We don't have the records.
Is that
in.
the only other than document?
I beg your pardon, I'm sorry.
Are those the only other documents between 7th grade and adulthood, or the Jacksonville Marine?
There was no records introduced at the evidentiary hearing. He
But you
testified
said
about
it's
it.
there. Well, I understand, but I mean, other information about those records. He had records from someplace.
He must have, or I don't know whether.
So again, is there anything else other than those now?
About his education?
Right.
No.
Okay.
The evidence in the school records themselves indicated inappropriate behaviors, but his mother testified about his having enrolled in the ESE as far as special reading programs and math programs, about he dropping out in 7th grade, and other relatives testified about his reading and math deficiencies, which really discouraged him.
Because in looking at the mitigators found by the judge at the original trial, apparently all of this about the abuse that he witnessed was all introduced.
Absolutely.
But with none of the downside of talking about what a dangerous person he
Exactly.
is.
And that's the one thing about it is the state did not contest that he had been physically abused by a father who used excessive corporal punishment, did not deny that he had been exposed to domestic violence in the household. And so but if you would have presented this evidence, all that would have come out before the jury. And Dr. Miller said, Douglas is a guy who knows right from wrong, but just chooses to do wrong. And that...
But again, let me make sure again, you said they didn't find mental illness. They mentioned brain damage. Did anybody document any kind of objective brain damage?
Justice Periente, in the post-conviction proceedings, in the record, collateral counsel Jeff Morrow asked for an MRI. He was granted an MRI. He transported Douglas to an MRI. He charged for an MRI, but no MRI records were introduced at the collateral proceeding. I think it's a reasonable assumption, why not? But there was an MRI done. It wasn't introduced into the
But most of those tests, like an MRI, I guess, doesn't really... isn't going to show this kind of like a frontal lobe impairment. I mean, there's I always think, again, you do search as a judge, as a juror. Well, what would make somebody, a 26-year-old, take a friend of a girlfriend, and because she said something that he found offensive, rape her and then strangle her and, leave her. And so you go back and say, well, what is it? Is it something that occurred in terms of a brain dysfunction? Or was he so traumatized by early childhood events that he really became a very ill, mentally ill person? So, but we're not, that's where I was trying to figure out, we're not really, what we're getting out of it instead is, yeah, things happen in his early childhood. Yes, was in ESE, but he got his GED, right? And
that's really unclear in the record. Now, his mother did testify that he started college at a community college, or started classes at a community college, but there's it was really questionable of whether he got his GED.
Okay, he had plans for self-improvement.
He had plans to get his GED.
Okay, so he doesn't, but the rest of his life after he drops out he's basically sells drugs.
Exactly, that's how, he works sporadically and he makes his living as a drug dealer. And,
Well, he presented, your counsel presented a picture that he has heavy substance abuse since age 13.
Self-report.
But in paragraph 27 of the sentencing order, it says no evidence of chronic or long-term drug and alcohol abuse was presented in mitigation. So is that a deficiency?
No, sir. And the reason why is, first of all, that's all self-report. There's not a single bit of objective evidence that he was such a heavy user of drug and alcohol. Now, his mother did testify that he sold drugs and he got into drugs, and that was brought out to the penalty phase, that he, was out on the street and having to sell drugs to buy shoes. But insofar as the objective evidence of his drug and alcohol abuse, no. And I think also, Justice Polston, smart counsel do not present inconsistent pictures. What they wanted to do was humanize Douglas at the penalty phase. I think most reasonable jurors don't really accept voluntary drug use and voluntary, we don't know, of course, Justice Parenti, what jurors think, but I think it's a reasonable assumption that jurors are not that sympathetic to voluntary alcohol and drug use. But what would have come out had counsel eschewed the humanizing? Because by going the humanizing route, the jury never heard he was convicted of domestic violence twice, never heard he was arrested for rape, never heard he was arrested for his part in a drive-by shooting. They never heard that. The ability to paint him as a good, mild-mannered guy would be gone, calling mental health mitigation.
You know, I've always wondered why defense attorneys do that. I mean, being a good, mild-mannered guy does nothing, in my estimation, to explain why someone would rape and murder someone. Those kind of strategies, to me, just, he was a nice guy, and then what?
Well, I think
one day he decides to rape and murder someone?
I think, well, Your Honor, the problem is that defense counsel have what they have. They have their client.
They have what they have that they've investigated.
But, yes, Your Honor, and again, I go back to the fact that there was antisocial personality known. But what I want to say is, judges, if you can, in fact, had counsel presented this mental mitigation, it would have done away with the one statutory aggravator that was, or mitigator that was found, that was no prior criminal history, significant activity,
but
criminal history.
A lot of those incidents that you're talking about, they were never really prosecuted, were they?
The rape and the arrest and the drive-by shooting were dropped by the prosecution for unknown reasons, but there was 2 domestic violence convictions, which of course would have tailored right into Dr. Miller's testimony about how he pulled a gun on one of the mothers of his children. So the fact is that, and if I could finish my statement, Justice Kennedy. The fact is that on the prejudice prong, had trial counsel presented this evidence that Douglas says now he should have presented, the jury would have heard that he's a violent, dangerous man, contrary to all the witnesses' testimony that he's amenable to rehabilitation, and at the end of the day, there's competent, substantial evidence to support the collateral court's ruling that there was no prejudice in this case, and that's what the state would ask you to find. Thank you.
Say one sentence about the strategy, and I promise I will drop it. The trial court and the state attorney respectfully disagrees with Ms. Carbulla. The trial court in a sentencing order found the majority of the mitigation to have very little weight, and said it was relatively insignificant as viewed as collectively. The state attorney in their closing argument called the mitigation a study in contradiction. So without saying more, basic mitigation wasn't done. This is not strategic.
Was the mitigator of no prior criminal history found?
Maybe Ms. Carbulla can answer that. It was not presented during the penalty phase to the jury.
Well, did the judge find it?
He found it, but he gave it very little weight because of Mr. Douglas's prior drug use that came out through his mother. Or drug, there was a term, you couldn't tell if he was selling it or using it, but the other point I want to make...
Do you agree was he selling drugs for a good deal of the time that he was after school?
I think the evidence strongly points that he was not only selling, but he was using.
What type of drugs was he selling?
That was unclear. I don't think the mother testified to exactly
what came out after in the self-report?
What Mr. Douglas talked about to the experts was I think it was cocaine, to be honest with you, Your Honor.
And you think that,
he was using
again,
and selling cocaine.
And trying to, and it is one of those double-edged swords. You know, he's a nice guy, but he does this. But he's he's not just a drug addict, he's a drug dealer selling cocaine to other people. You think, I think that it's tough stuff there that would...
It's tough stuff in every death penalty case,
yeah,
especially
but
with somebody...
and I agree, and the question in this one is, what you brought out is our confidence in the penalty phase undermined.
Well, Mr. Douglas, it's clear that he had, there was neurological testing done by Dr. Kropp. He did a series of tests. He found there was frontal lobe disorder. Combined with his low IQ and his emotional issues and deficiencies that were found since he was going to essentially kindergarten, you can create a nexus where these subsequent crimes are less blameworthy for a person with these deficiencies. This was a screwed up kid that continued to do it without the adequate treatment, resulted in drugs, and it just became essentially, unfortunately, a ticking time bomb.
It's one thing if he had, shot somebody in a murder shot someone in a robbery, a drive-by, but what is it that explains what must be his contempt for women, 2 domestic violence convictions, and then this being a rape murder? Explain to me what it is that in his childhood that would explain his taking out his anger or his violence on women?
Well, there was definitely domestic violence from his own father to the women in his household. So
you just say, so did someone explain that a cycle of domestic violence, was that a theory? Because that's a different theory.
Dr. Miller said that Mr. Douglas was doubly cursed, dealing with his environmental issues combined with the abuse that he saw and was personally...
So you think a picture of saying because he witnessed domestic violence, he mimicked that, and he himself became an abuser of women, that would be a good mitigator in the case?
No, I think it's an explanation of why he would... there's going to be negative things that come out in Mr. Douglas's life. He was having these negative things before, he was literally going to middle school. And it transcends into, unfortunately, a life of
But what did he do to try to help himself? And that was the Jacksonville Marine Institute records. Those are sort of, the jury hears that and they go, here's a guy, he's struggling. He didn't have, his IQ was not the highest. He had, other issues. But what did he do in his life to try to overcome it?
Well, neurological impairment and frontal lobe damage, one of the main characteristics is lack of motivation. And I think combined with his depression that Dr. Miller did find and diagnose with, which he also said was apparent, or at least was in existence at the time of the crime, along with the statutory mitigator of extreme emotional disturbance, coupled with the fact that there was reports of them drinking a pretty good amount of alcohol during the night in question. Of course, the trial court in the sentencing order said that Mr. Douglas was driving around, so it must have not been that much alcohol. But you have a group of things that, when put together, can create pretty substantial mitigation to the jury in my own experience. And it's very difficult to find a client with no negative qualities about them. And lastly, I have one more thing to say. I encourage the court to read the state's closing argument, because it essentially dealt with Mr. Douglas's accountability and how that he was on the end of his chosen path, and to hold him accountable because he had all the tools to succeed. He did not. He chose what he did and used the defense's respectfully poorly conceived mitigation strategy, because that was the only strategy they had against them, and it reflects in the jury's 11-1 decision. There was no premeditation found, and there's still 11-1 verdict. Yes, I understand there was an HAC aggravator found and a prior violent felony, which happened to be the sexual battery, but 11-1, the jury, in my opinion, was thinking the same thing the judge and the state attorney were, is these mitigating factors are insignificant. They don't explain anything that happened in the crime. At least these would have given the jury something to hang their hat on and say, okay, I understand.
Your time is up.
Thank you, Your Honor.
Thank both sides for your argument. The court will now take a 10-minute recess.
All rise. Supreme Court of Florida is now in session. Please be seated.
May it please the court, good morning. My name is Robert Mohler. I'm an assistant public defender with the 10th Judicial Circuit. I'm here on behalf of
I should say this is the case of Parton versus State of Florida.
Yes.
And this is the case with the 37-year-old defendant.
Yes.
Okay.
Okay. That's correct. Mr. Parton was sentenced to death after a 9-3 jury vote recommending death. I'd like to start out with the first issue that's addressed in the briefs having to do with certain evidence that was presented at trial that we feel should not have been allowed, having to do with other crimes and bad acts. We've identified in the brief 7 separate instances of this type of evidence that was allowed in over defense objections. The first example is in a recorded telephone conversation between Detective Scott Gattuso.
Could you just speak up some, or at least speak it more directly into the mic, please?
Yes, I'll try to do that. I'm sorry. There was a recorded telephone conversation between Detective Scott Gattuso and the appellant in which the defendant referred to having firearms and knowing he was not supposed to have any. Another example is there was a videotaped interview with law enforcement after the defendant's arrest where the defendant spoke of having his gun with him everywhere he went and possibly of shooting it out with law enforcement.
Well, okay, so to me, there's 2 different things there. One is knowing you're not supposed to have guns, I could say is not relevant, or, you know, I think that's debatable. But give me the context of saying he was always keeping his gun with him in case law enforcement found him. In the context of this case, where he successfully evaded arrest for how long?
Well, the offense occurred July 31st to August 1st, 2002, and he was arrested in October 2003.
So a year
Over a year.
plus. He was on the run.
Right.
And you would agree that not running after a crime and with knowledge, flight, is relevant to consciousness of guilt.
That's what the cases seem to indicate,
Okay,
yes.
so my concern is that in the context of tell me the context of the one where he said he always keeps a gun with him in case law enforcement found him, why that's not relevant in the context of consciousness of guilt and knowledge of that he was being sought for this crime, which is where I understand all of these comments all came in under that, exception or that theory.
I think that's correct, it did.
So what's wrong with that one not being right on point?
Well, rather than isolating just that
Well,
one.
I'd like to just take that one, because
Just take that
otherwise, because you brought it up, let's take one, which is, that one is one, he always kept a gun with him in case law enforcement found him. You know, that's a bad, wow, somebody's going to shoot up law enforcement and they have a gun. You know, you'd say, well, that's prejudicial, but, so let's talk about that one.
Yeah, well, I think that's another part of our argument, is that all these things are more prejudicial than probative. I'm not going to say that that has absolutely no relevance whatever, but a big part of our argument is that all these things that came in are more prejudicial than probative.
And how was that? I mean, what was prejudicial about it? And if it was...
Well, I think in particular, I could, rather than just isolating that one, again, I'd like to lump them all together and say that when you consider all this evidence about, there were several examples of testimony about him having guns, and this one about shooting it out with the police.
Okay, well, let's just take the guns. Was there other statements that you take issue with that would have anything to do with prior bad acts?
There were a few other examples beside the gun thing. For example, when testimony from Parton's former girlfriend that he asked for her ex-husband's social security number. That's one example of another bad act, suggesting that he had some sort of a fraudulent intent. And another one was, well, this one is particularly, I think, egregious because it doesn't even have any marginal relevance, is when in a tape of a telephone conversation between Parton and his friend Fred Kaufman, Parton was describing being in a fight, apparently at some beach area, and engaging in a fight with another person. And there was a mention by Parton that the man's head was split wide open. And it's not clear to me whether he meant that he split the guy's head open or if somebody else did that, but the fact that he was in this fight basically portrays him as a violent individual.
So what was as I understand it, there were some parts in that conversation with Fred Kaufman that were relevant, but the argument is that this was not, but somehow I thought the trial court found they were used inextricably intertwined. So could you give us the context of that conversation? What else was stated during the conversation with Fred Kaufman that would have been relevant?
Well, I think Parton at that point was basically telling Kaufman where he'd been and what he'd been doing, if I'm remembering that conversation correctly.
Well, that would seem, I mean, based on your portrayal, that you would be absolutely right. It wouldn't even be relevant. So I guess we'll have to hear from Ms. Blanco as to why that would come in, because that...
But if you take all of these, what really, I'm trying to get, what is the prejudice that a jury, that you're saying, the reason the jury should not have heard this? What's the prejudice from these statements?
Well, basically, I think the prejudice is that it portrayed Parton as this violent, gun-toting individual, and this would have infected not only the guilt phase, but the penalty phase as well.
Well, certainly in the penalty phase, they would have heard about his prior murder conviction, wouldn't they?
They did hear about that, yes.
So how, in connection with the prior murder conviction, I'm not sure that I see that the rest of this would have been that prejudicial.
Well, because these are additional, several separate incidents where he's carrying a gun, and this murder, this homicide did not involve a gun at all, nor did the previous murder involve a gun.
Well, it would make it, actually, they say that makes it less prejudicial because since a gun was not used, a knife was used in his hands, that there's nothing to infer that he committed this murder because he was trying to avoid arrest. I mean, so this is, it does seem to, I mean, again, I tend to agree that I'm not sure why all those statements needed to come in, but I'm not just, again, on the other, that there's relevance, and then the issue, though, is that the prejudice outweighs it, and I think that was where Justice Quince was going, is that how prejudicial really is it in the context of what they heard about this crime and the circumstance of this crime, and then you had him with physical evidence linking him to the victim and the crime, the hair on the victim, the DNA on the carpet in Parton's room. Hard to say it wasn't him.
Well, yeah, then that sort of raises the question, why did they need to have all this stuff?
We many times ask prosecutors, why do you put things on?
Overkill, sure, I understand that. But again, to me, when the jury's hearing all this stuff, he's toting guns and thinking about shooting it out with the police and so forth. It just seems to me it portrays him as a violent person above and beyond whatever he might have done.
Well, that was why I was trying to find out
right?
the context. You know, if for somebody said, I saw him 2 days before the crime and he was carrying guns, we'd say, no, that's not coming in.
Right.
Okay, right? We'd say, no relationship to the crime.
Correct.
The fact that he might have been arrested a year before because he split somebody's head open but wasn't prosecuted, not coming in the guilt phase.
Right.
So I was trying to get the context that the jury was hearing it in, which was he's on the lam, knowing he's being sought for this murder, and he's telling people that they're not going to get him because he's got guns. It seems that it's relevant in that, because of when it's being said. We would agree generally that before the murder, it would be bad character evidence. It wouldn't be relevant.
Mm-hmm. Well,
is this the case where he also wanted the police to meet him without, and he didn't want the police to bring a weapon to this meeting site? And so it seems to me that, at least in that context, the fact that he had a gun and he's negotiating or trying to negotiate with the police and say, yeah, I'll meet you and let's meet at this location, but you have to agree not to bring a weapon. I mean, isn't that this whole thing that he had a weapon sort of tie in to him not wanting the police to come to the site and with a weapon?
Well, I don't know that those two are really connected that much, because I don't think that he was saying he was going to bring his gun to the meeting, but the police couldn't be armed. That's not the way I
well, I'm not saying that he said he was going to bring his weapon, but he didn't want that. But the whole idea that there was some discussion in this case about a weapon and not wanting the police to bring a weapon to their meeting seems to me that there's at least some marginal relevance to his possession of a weapon.
Well, that doesn't really seem, to me that's like a tangential matter. If he was going to meet with the police and if he was going to be armed and wanted them to be unarmed, I don't really see the importance of that. Okay. If I could, I'd like to move on now to the second issue, which has to do with the...
I'm sorry, go back to the one thing which I don't feel like you answered. The conversation with Fred Kaufman. What was that? What part of it do you agree was admissible? What was it being offered for? Just that he must have talked to him about something other than having had a fight Do you recall, or would we need to just go back to your briefs to figure that out?
I really can't help you out very much there, I'm sorry, but I really don't remember much about the context.
I mean, what
of
your
that.
impression was in reading this record, there was the sum total is was a lot of things that you thought was extraneous, bad act portrayal evidence that didn't need to come in.
Right. And with some of these tapes and conversations, some of them were rather rambling, and it's a little bit hard to see what the point of it was. Moving on to issue 2 in the briefs, having to do with the admission of former testimony of Susan Eulery, who was a DNA expert witness for the state. She had testified at Parton's first trial, which ended in a mistrial. And at the time of the new trial, this witness, Susan Eulery, was living in San Diego, California, and was 4.5 months pregnant.
Can I let's take out the pregnancy. Somebody now is living in another state.
Mm-hmm.
Does that not allow their deposition to come in or their former testimony if it's taken under oath and there's cross-examination? Or does unavailability have to mean that they can't travel?
I haven't seen any. She has to be unavailable, and I haven't seen anything that would allow somebody who simply lives in another state to be considered unavailable.
Well, if they're a lay witness and their deposition is taken in another, so is it because she's an expert?
No, I don't think that really has anything to do with it.
Well, you're telling me that if there's an out-of-state eyewitness whose deposition is taken,
mm-hmm.
that the one side or the other has to bring them to trial?
She still has to be unavailable, yes.
I think in the civil rules of procedure.
Oh, it's different
there's a provision for experts who are more than 100 miles away that you are permitted to read their testimony.
But in criminal, they got to bring them.
In criminal, it is preferable always that the witness testify.
Well, I realize it's preferable. So there has to be actual unavailability.
That's my understanding. Yes, that's correct.
And the fact that her doctor says she shouldn't travel isn't enough to show unavailability?
He didn't say she shouldn't travel. He said that she shouldn't fly. The defense had 2 suggestions. She could come here by other means. She wouldn't have to fly necessarily, car, train, bus, whatever. Or the trial could be continued until she was available to testify.
Which was months later.
Several months later. I think the trial was in, March, I believe, and she would have been available in August, I believe, to fly at that time. And the defense had no objection to that procedure, a continuance.
Did you feel like there was something missing in the first cross-examination? In other words, I guess the other protection, if we're looking at whether there's discretion,
mm-hmm.
she's unavailable, I really don't think requiring somebody who's not supposed to travel to have to put them on a train or a bus from San Diego to Florida is what I would consider to be something the court would want to endorse. So my question, though, is was there something that you said, well, she was cross-examined, but what we really wanted to do is the jury needed to see her because she was fidgeting? I mean, anything that would, and maybe I'm just going to the due process part of this,
mm-hmm.
but just trying to get at where the prejudice really was to the defendant from her not being able to be present at trial.
Yes, well, I think during the hearing on the question of whether this former testimony should be allowed or not, the defense counsel did make the point that it was a little unclear to me exactly what he was saying, but his cross-examination during the first trial was abbreviated for some reason. I'm not sure exactly why, but he indicated that basically that this trial could be different. He doesn't know how the testimony is going to come out in this one. His cross-examination could possibly be different than it was in the former trial, and that he didn't we have another expert in this case who testified to essentially the same information? Well, this witness testified to at least one important piece of evidence that the other DNA experts didn't, and that is there was a carpet with a stain on it in the room in Fred Kaufman's house where Parton had been staying with his daughter. And this, I believe this was the only DNA witness that identified the DNA of the victim on the carpet from that room. So,
But we all, was it disputed that she was in fact in the room with the defendant's daughter at some point during that day? I mean, that's a fact that was not disputed, is it?
no, it wasn't really disputed. Let me also mention one thing. The state's comments during the hearing on whether to allow this former testimony or not, this is the prosecutor speaking. I would suggest in this particular case we have Susanna Eulery Ryan, that was her married name, who is a very material witness in the case. I don't think defense counsel would argue that she's non-material. She is material. She is necessary. So the state thought this was a very important witness, and if you have a very important witness here, in a capital case, the defense should have the right to see the witness and confront and cross-examine the witness and not have to rely on just her former recorded testimony.
Was it the same defense attorney?
I'm sorry?
Was it the same defense attorney as the one in the former trial?
Yes, I believe it was.
Is it, if we find that, okay, so what we'd have to find that she wasn't available is that the trial court is in an abuse, how is unavailability defined? And is it an abuse of discretion standard as to whether in the trial court's finding of unavailability?
Yes, I believe that's correct.
Okay, so we'd have to find that and this is where I think I'd have the trouble finding it, that that he abused or she abuses his or her discretion in finding that a witness who was 4.5 months pregnant, whose doctor told her was not safe to travel, to have not ordered her to come by means other than an airplane. And it just seems like that rule of law there's just something that I'm having problems with.
It seems a bit inhumane, or?
Well, it seems that unavailability is physical, that you have a physical illness might make you unavailable, that's an appropriate use of the statute. The other question I have is that if we found an abuse, is the standard it's per se reversible, or do you have to demonstrate that it was some error, some effect on the trial?
Well, I think because of the importance of the confrontation and cross-examination provisions in the Constitution, that basically trumps any inconvenience to the witness.
I mean, and there I have you cross-examined, so I don't think you have a Sixth Amendment argument. Let's say that we say the judge erred in the way they defined unavailability.
Right.
Then is it an automatic reversal, or do you have to show how you were prejudiced? And you say, well, I could show it just because I should have had a right to cross-examine her in person, and that's the prejudice. Is that the standard of reversal?
Well,
it's like, is it a per se reversible reversal?
I would almost have to say yes, because
well, what does the case law say about it?
I'm sorry?
Is there a case law that says that if there's an abuse, it's per se reversible, or?
I can't point to a case that says that exactly, but it seems to me that the cases say you have to have two things. You have to have unavailability, and you have to have had an opportunity to cross-examine in the past. And if you don't have one or the other, then you just can't use the former testimony, period. I think that's consistent with Crawford and the other cases that deal with hearsay and the exceptions to it. The next issue that we've briefed deals with the refusal of the court to allow appellant's jury to have a copy of the indictment in the jury room or to have the indictment read to them. Twice the jury requested to have the indictment. Well, first they requested a copy of it. The court said no.
Was it read to them by the judge at the beginning?
At the beginning. I think it was, but I'm not quite sure. The reason, well, they asked for a copy first, the judge said no, and then they asked to have the indictment read to them.
And the judge said no to that too?
Yes, he refused both.
And so isn't this, again, is an abuse of discretion standard, isn't it? Because at the time of this trial, you did not have to give the jury a copy of the of the indictment, correct?
That's correct.
And so what was the prejudice? What that was demonstrated by not giving the indictment?
Well, the only thing I can say is that obviously the jury was very concerned about something in the indictment since they asked for it twice. My speculation is that maybe they were concerned whether the allegations met the proof, but I really can't say that. Since we don't have any more from the jury as to why they wanted it.
Well, let me look at it this way. Did the defense attorney object to the trial judge's decision not to give them the indictment?
I believe he objected, but at least, I don't know if he objected or not, but he requested that the indictment go back.
Okay, and was there any request on his part when they said, no, I'm not going to send the indictment back, to redefine first-degree murder?
No, I don't believe it was. It might be useful to know the judge's rationale, apparent rationale for not complying with the jury's request. Rule 3.400 of the Rules of Criminal Procedure provides that the court may permit the jury, upon retiring for deliberation, to take to the jury room a copy of the charges against the defendant. And it appears that the judge was somehow concerned that because the jury had already gone out to deliberate, it was too late then for them to receive the indictment because of the language of the rule which says, upon retiring for deliberation, the jury may have the charges. So that I believe that was why he denied the request.
Counsel, you're now down to about 6.5 total minutes, so you've moved into the time you had indicated you wished to reserve for rebuttal.
Thank you.
You can continue, or?
Yes, I want to continue just for at least one other issue here. And that has to do with the issue of the death sentence itself. Of course, there was a 9-3 death recommendation. The court found 2 aggravators, hack and prior violent felony. The prior violent felony happened over 20 years ago, in 1987, to be specific, when Parton was only 22 years old. In this case, there was compelling mitigating evidence.
He was only 22.
Right.
He'd served 5 years, so in prison, or 6 years?
I'm not sure how long he served. I don't remember seeing that in the record.
5.5.
Okay.
So he was in prison for most of his 20s. It's a significant crime. He murdered someone else. Right. Correct?
Yes.
Do you see that as being a significant prior violent felony under our case law?
Of course.
Okay.
Yes, but the main point I wanted to get to has to do with the mitigating evidence that was presented and not presented to the jury. The defense initially presented a very minimal case in mitigation to the jury, and then presented what I consider to be much more compelling mitigating evidence at the Spencer hearing.
So we're going to be hearing about this in post-conviction?
I'm sorry?
Sounds like a post-conviction argument.
Well, it may be, but it's sort of my pet peeve when the jury returns its recommendation and then additional, much more compelling mitigation is presented to the judge only. I have a real problem with that, because even the judge recognized in his sentencing order that a situation like this may entitle the jury's recommendation to less weight when you have a situation like this. But to me, it goes even beyond that.
What was the rationale for presenting this evidence at the Spencer hearing as opposed to at the penalty hearing?
I think there were 2 things that the defendant may not have wanted it presented at the penalty phase, and beyond that, the defense appears to have had some trouble getting its evidence together. Specifically, they wanted evidence from Parton's biological father, Lester Vieco, and at first he was very non-cooperative, and then he decided to cooperate for a while, and then he stopped cooperating again. So some of that evidence only came out after the penalty phase. But anyway...
Well, you have a pet peeve, but a pet peeve has to translate into, again, a rule of law that says that it's... where's the error? In other words, it may be deficient performance, which not on its face, we can't tell that, but we allow additional evidence to be presented at the Spencer hearing. So, you know, and some of the strategic reasons are it comes out like that they're antisocial, but the judge is going to be maybe more understanding because they hear it all the time. How does that translate into anything that would be reversible error on direct appeal?
Well, what I was trying to get to is it calls into question the reliability, to me, of the jury's recommendation, which I think is something this court can consider on appeal. And I do think that maybe there should be some type of a rule that would prohibit this situation, such as maybe requiring the defense counsel to present all available mitigation at the penalty phase. I don't know. There must be a remedy out there somewhere, and I would certainly like to see that happen. I'll save the rest of my time for rebuttal. Thank you.
May it please this honorable court. Your honors, my name is Katherine Blanco with the Attorney General's office in Tampa, representing the state of Florida in this direct appeal. I would like to also address the issues in the sequence that opposing counsel has addressed them. With this court's permission, I'd like to separate the individual motions in limine and then address them cumulatively. It may flow a little bit easier and help my understanding.
Well, yeah, because the impression we end up getting is that this trial consisted of all these comments that he makes after when he's on the lam about owning guns and splitting people's head open, and it's like, what? Isn't that an awful lot of this? And obviously the defense lawyer was aware of it because filed a lot of motions in limine about it.
Sure, Your Honor. In this case, the state presented 46 witnesses. The trial was over 5 days. The presentation of the state's case, the sequence, the first day was devoted primarily to the discovery of the victim's body, and so you have the officers, the witnesses on the scene that discovered the victim's body, the crime scene investigators, the follow-up trying to get leads. So you have the first day of that. Actually, the trial starts at volume 40 of this 56-volume record. And volume 41 then goes on again to law enforcement officers' efforts to obtain physical evidence. There were really 3 different types of evidence in this case. You had the physical evidence, which of course included the crime scene photos, the hair, the fibers, the blood, the DNA. You also had the testimonial evidence from the witnesses on the stand, and you also had the statements from the defendant that came in primarily in volume 44. And so you have, again, 46 witnesses in total. The tapes that the defense is complaining about, or the statements the defense is complaining about, are all those of the defendant, in fact. So, and based on the defendant's own actions. You have, with respect to motion in limine 4, which is the first motion that's dealt with in the defendant's brief, there are actually 3 calls to Detective Gattuso by Parton, by the defendant Parton. They're on August 27th, September the 4th.
The defendant is making all of these calls.
The defendant is placing the calls to Detective Gattuso. Okay. Early on in the investigation, within 2 days of the finding of the victim's body, another detective gets the phone number that is linked to a phone in the defendant's possession. She gets this phone number because the victim's boyfriend, or former boyfriend in any event, the mother, has a call that she receives on the morning before the victim is killed, or before her body is discovered. And so she records the caller ID. The victim, Jo Shan Ashbrook, comes to her house briefly, drops off a note. Iris Mancero is the mother of the defendant, or excuse me, of the victim's former boyfriend. She sees a red truck, a distinctive red truck. She doesn't see who's driving the truck, but she does see a fairly new burgundy pickup truck. And so law enforcement, through this lead, is able to contact the person with the phone. Detective Mazzo calls this number and speaks with someone that she doesn't know, but they identify themselves as Philip Thompson, false name given by the defendant, because we later learned that it's actually Parton that is called. Asks what type of car he is driving or vehicle he's driving. He says a blue 72 Chevy truck, nothing like the newer modeled vehicle that he actually is driving. And also, can I meet with you? Can I talk to you? And says, I'm a transient, I'll get back to you. Detective Mazza's efforts to set up a meeting and talk with Parton are unsuccessful. Then Detective Gattuso enters the picture, at which time the calls are placed from Parton. There are 3 calls to Gattuso. Of those 3 calls, there's only one that's identified as having one paragraph that's excerpted in the defendant's brief, which has to do with statements about, I know I'm not supposed to have firearms. There's that line in that excerpted paragraph.
I mean, let's just take that one. And
certainly.
What is relevant about saying, and isn't that prejudicial? I know I'm not supposed to have guns. Why does that come in? Or is it just you can't, it's just linked in terms of how the statement is being made?
Justice Periente, with the court's indulgence, I'd like to explain exactly how it came in.
Sure.
This is the August 27th conversation. The defendant's motion in limine, in volume 10 of the record, at page 1734 to 42, sets out the complaint with regard to the phone calls. There is never a date attributed to August 27th, 2002, identified in that paper motion. At the commencement of the hearing, and the hearing starts at volume 24 at page 3920, the trial court is going through page by page of these transcripts, and the prosecutor's Xing out things, taking stuff out, trial court's Xing out, and so the trial court says, well, does your motion relate to August 27th? And defense counsel says, I believe I overlooked that. I'm sorry, we'll get to that later. Towards the end of the hearing, they come to the last page of that motion in limine, which has a statement attributed to September 22nd, 2002, and it is in fact this statement. At that point in time, even though there's not a September 22nd conversation, the prosecutor says, we'll take out that September 22nd. We'll take that out. So it appears that there was a ball dropped here somewhere.
Okay, so what you're describing, let me just make sure, because you're describing a process in which the prosecutor and the trial judge was very aware of trying to excise things that would be either irrelevant or prejudicial. You're saying on this one, whether conceding or not, it maybe should have come out and it just didn't. And that's an acceptable, I appreciate that. So let's go, but what you're again telling us is it was a careful process by the trial judge to try to ensure that nothing irrelevant came in.
Absolutely, Your Honor. And we have argued a procedural bar in part, and I have filed a notice to the court because unfortunately our state's answer brief included an assertion that statement was not included in the defense motion. That has been corrected. It was included in the defendant's motion. I apologize for this. It was attributed to a September date.
Is this the statement? So I'm trying to figure out, there are so many of these statements. Is this the one where he's negotiated with the police officer about meeting and he asked them to be unarmed? He says he's presently unarmed, although he's had weapons, but he secured them all, so now I'm unarmed and you need to be unarmed.
Exactly, Your Honor. We do believe that the bulk of the statement is relevant and should have come in and would have properly come in. I believe that the prosecutor was being generous in agreeing to take it out. So I believe that we have a solid relevancy argument. So we have first an argument that we do have a procedural bar in part because when the statement was played, and this is a short transcript. This is in volume 44, 1108 to 1116. It's 8 pages in the transcript. It's 2 sentences within 1 paragraph where you have that, I know I'm not supposed to have them. Well, of course, not supposed to have them. The defense is saying, well, that necessarily means that he was a convicted felon. It certainly could have meant that he didn't have a permit for it. But to make that leap that somehow this entire trial is contaminated by those 2 sentences that were not excised when the prosecutor had agreed to them. Believe that the statement is relevant to show the parameters that the defendant's setting up, demanding that law enforcement come unarmed, condition, of course, that's never going to be met by a good detective. But even if the court were to say, we're going to assume error, even if you were to go that far, and we do not believe it's supported on this record, but you have harmless. And of course, the error was unimportant, error if any, and we're arguing there was no error at all.
Well, it sounds like it wasn't preserved in this regard, is that if it was agreed to be excised, then at that point, when it was coming in, the defense lawyer should have said that should be excised. So
correct? Although there was a preliminary objection, when the statement was actually transcribed at trial and played, no one jumps up and the defense doesn't jump up and says, hey, that was supposed to be taken out. There's no request for a curative instruction. I think indicative of the fact that the defense doesn't notice that the jury's hearing, you know, a tape coming in that is relatively short in the scheme of things, and certainly much smaller when you look at the two sentences that are in that one challenged paragraph.
The one that because you have limited time, the only other one that caused me concern was this Fred Kaufman conversation about splitting open the head. Could you give me the context of that?
Certainly, Your Honor. That addresses motion in limine number 12, and that's a phone conversation with Fred Kaufman on October 27th of 2003. Remember, the defendant has been on the lam for a year and a half. Now, he knows law enforcement's looking for him. There is some type of fight. He's not attributed to starting the fight or having anything to do with the fight other than jumping in at some point. The relevance for this from the state's arguments, Your Honor, and the state standpoint is not the fight. The relevance is he's there with law enforcement knowing that they want to talk to him. He's getting patted on the back. He's bragging about not having to give up his name, that he was successful in avoiding detection. So it shows that this defendant, throughout this course of conduct and wanting to evade apprehension, that he has contact with law enforcement. He doesn't identify himself, knowing he's wanted for questioning. It's consistent with...
But what about the incident, and maybe it's where the head is split open? Where is that? I mean, if during the year and a half he's on the lam, sure, he does things like he has girlfriends or other things. I mean, would you say every single thing that happened in the year and a half would be able to come in because he was escaping? You wouldn't say that, would you?
Well, escape, certainly I would.
I mean, not escape. I'm saying everything that happened in a year and a half, every action he took could come in.
I'm saying that every relevant admission by him and effort to avoid detection,
okay, so what
absolutely.
was maybe I missed again. What was the relevant admission about the head being split open?
Okay, the fight itself is not relevant, and the prosecutor did not dwell on the fight, doesn't even talk about it in his closing argument.
Was that was that part objected to?
It was part of the motion in limine to keep the entire conversation, the entire discussion out.
But then once the judge said, I'm going to put it in, or do you have objections to part of it? Did that conversation take place?
It was redacted in part, I believe, Your Honor. I cannot give you the exact lines that were redacted in part. Again, the judge went to great efforts and the prosecutor went to great efforts. You know, we'll keep out that he was in jail before. We won't have any reference to the firearms that are in the Florida house. We won't have any reference to the 45s. The 9mm comes in because that's what he's got with him, you know, at the time that he's contemplating shooting it out. And so, as far as the focus of the fight, the way the defendant represents it is that he's coming to this woman's rescue, and that she is being beat up by this guy. He says, hey, you know, pick on me or something like that, take it up with me. And so he almost portrays himself as some type of a knight coming to her aid. But the relevance was not the fight, the relevance was the contact with law enforcement. And that was how it was argued below. And the trial court found that it was inextricably intertwined, that it would show the defendant's, and this is the trial court's finding, to show the defendant's efforts to avoid detection and arrest, and hence his consciousness of guilt. So he concealed himself, he avoided making a statement, giving his name, and all to avoid detection and arrest. And we've cited a series of cases from this court, Straight, Thomas with regard to escape, Wyatt, the decisions in there, Taylor as well. If the court has no further questions on the motion limine, I'll be happy to move on, but okay, thank you. And there were others, and certainly we would rely on the arguments in our brief for those. And I guess if you allow me just to finish with respect to my harmless error argument from my first, the motion in limine 4, where there was some confusion about what was preserved and what was not. Philip Parton was the last person seen with Jo Shan Ashbrook. He called her Joe. The defendant fled almost immediately when he was notified he wanted for questioning. The defendant's truck tire impressions led to her dead body. As a matter of fact, they made cast of those tire impressions. The defendant's hair was found embedded in her bloody hand. Now, this is significant because the defense, of course, will always argue, well, there's some kind of transfer. But the victim had injuries to her hand as if she had grasped a knife, and there is quite a deep cut in her hand. And the photos show her bloody hand, and they actually show this particular hair that is embedded within that wound on her hand. Fred Kaufman, the hair was analyzed. Nothing leads to Fred Kaufman with respect to any of the hairs or any of the people that were with or that had contact with Joshan's body that morning, because the defense theory was, well, Fred Kaufman did this. Fred Kaufman had not met the victim. Fred Kaufman had not had contact with the victim. Fred Kaufman had was not introduced to her, was not present at the time that she disappeared, was not with her that day. But the defense theory is because it was in the home that Fred Kaufman somehow was the murderer. The defendant's car was seen at 4:15 that morning. The defendant had a very distinctive vehicle. I've previously addressed it. It was a burgundy color Ford F-110 pickup truck. So the witness that sees this, Art White, is coming around the bend. This is a curvy road in Pasco County. He's coming around 4:15 that morning. He had to take his wife to the airport for an early flight. And he sees a truck backed into an area that's and actually within 10 feet of where the victim's body was found. And he describes it as a pickup truck. He's familiar with trucks. He's a long-haul truck driver, so he knows what a truck looks like. He says it's not an extended cab Chevy Silverado, which is what Diane Kaufman drives. It's not an SUV, which is what Fred Kaufman drives. And he said that there are shiny tires, shiny grill, and he says it looks dark. Well, there is, in fact, on the front of the grill, above the grill on this burgundy truck that belonged to the defendant that he was using, there is a large bug guard. And so that would be consistent. And of course, it's 4:15 in the morning. Nobody disputes that it's dark outside. So you have all of those links coming into play with his presence, where the body was eventually discovered. And the body's discovered, remember, you've got Joshan leaving her mother's home at 2:30 in the morning. She has run away before. She's 16 years old. She leaves at 2:30 in the morning on July 31st.
Let me ask you about that timeline, though.
Sure,
because
certainly.
I thought I remembered the testimony from Mrs. Kaufman.
That's right,
The
Diane
defendant
Kaufman.
left with the girls, I guess, and he came back alone at 1 a.m. And so how does that play into this 4 a.m. scenario with this other truck driver?
Certainly, and the medical examiner estimated the time of death at 3:30. She doesn't know if. Bless you.
Pardon me.
She doesn't know if the defendant, if Parton then left again. There are sliding glass doors from his bedroom, and so she couldn't testify whether he left again. The ME testifies that the murder would have had occurred before 3:30 a.m. or approximately around 3:30 a.m. And certainly the victim's body could have been in the pickup truck. There was evidence of ligatures around her wrist and around her ankles. And so it is certainly conceivable that when Parton left and then came back alone, the victim's body was still in his pickup truck before he goes later to dump it. Alongside of the road. He dumps her body in the side of the road. She's got severe lacerations to her face, slit across her throat. That's not what kills her. However, what kills her is the snapping of her neck because it severs the spinal column. And she certainly fought, and medical examiner testified to the defensive wounds that were on her hands. She's taller than Parton. She's tall and thin, and if you see both the video of the Walmart video and the still photos, Parton's not very tall. I think there may be something about 5'3". I'm not sure if he's that size. But anyway, there is a discrepancy. She's tall and slender. And in the Walmart video you see, and the still photos, you see Joshan, and you see Parton's 7-year-old daughter, Patricia, and then you see Parton, and you see the height. So she would have been able to put up some force and And she did. She tried to save herself, certainly. The second issue.
Well,
I'm
just
sorry,
a
Your Honor.
final issue on all these motions in limine is the information about Social Security numbers.
Sure.
How in the world? What were those? That information. There was something about the girl, and then there was something about Kaufman's Social Security number. Correct. So
That's true.
how were those at all relevant in this?
Those are relevant under this court's case law, especially Murray, Your Honor, where there was no evidence of false identification cards found at the defendant's arrest. Again, this defendant's operating under an alias. He goes to Washington State. He buys a vehicle under the name of Fred Kaufman. He signs the name Fred Kaufman. And so we've argued they're highly relevant to his intent to evade capture by use of an alias, not only to evade prosecution, but law enforcement detection by the use of an alias. But also, Your Honor, those cards would certainly be harmless because you have in-court testimony, witnesses who identify Mr. Sandy, especially as the man who represented himself as Fred Kaufman in Washington and bought the vehicle in Washington as Fred Kaufman. And so you have, and the state's case, was very intricate, the way that they had to weave all the circumstances together, not only with the discovery of the body, but the efforts to locate the defendant, the phone calls, the linking this defendant to this crime. Remember, after this murder, the defendant leaves what is most important to him, well, two things that are most important, behind. He drops off his 7-year-old daughter with her former foster mother. He leaves his truck behind, and when the truck is left in a Walmart parking lot in Plant City, which is about 50 miles from where the site of the murder was, the tires have been changed out. But he forgets that he has left in the Kaufman house a disposable camera. Those pictures are developed in that disposable camera. What do we have? Lo and behold, there's pictures of the truck with shiny tires, shiny new tires that are unlike the tires that have been put on that vehicle that's been abandoned. And those tire tracks are consistent with the tire tread that is leading to the victim's body. So the state calls in tire track experts, people that are familiar with automobiles. It was a very intricate weaving of the case and all the circumstances. And you have, in October, the defendant moves out. Victim's body, of course, is discovered August the 1st. August the 2nd and 3rd, you have attempts by Detective Mazzo to meet with him. August the 5th, defendant shows up for a job. He's real agitated. He's on the phone. Turns out this is his former girlfriend, Susan, in North Carolina, that has contacted him because law enforcement has contacted her. Why? Because the cell phone he's using is in her name. So it links back to them. So he's first day on the job. He ends up walking off. August the 10th, he leaves his daughter behind. He flees the state of Florida. He changes his name. He changes his appearance. He gets multiple tattoos. He has facial hair that he didn't have before. So he goes through great efforts to disguise himself and to not be found. And so with respect to the Social Security cards, Justice Quint's question, it's admissible under Murray, that false identification which he used, and the in-court testimony which supported that he represented himself by another name. Issue 2 has to do with the testimony of Suzanne Ullery, FDLE agent. This is in response to an earlier question, I believe, by Justice Periente. Justice Periente, the definition of unavailability, if you'll allow me, in Section 9804, parenthesis 1, parenthesis D, says, unavailability as a witness means that the declarant, D, is unable to be present or to testify at the hearing because of death or because of then existing physical or mental illness or infirmity. And it comes in as a hearsay exception under Section 2, Section A as former testimony.
But the rules of criminal procedure also provide a procedure for perpetuating the testimony of a witness whom you know is going to be absent.
Certainly, Your Honor.
And that is in 3.19I. And in this particular case, the witness, the state was aware of the fact that the witness would not be able to come and testify, and the procedure is for the lawyers to travel to San Diego and take her deposition, perpetuate the testimony there, and then play that testimony to the jury. That is a procedure that is unique to the criminal rules of procedure. In civil procedure, of course, you can just play the tape or read the transcript. But in criminal, you have this petition to perpetuate testimony. And I think counsel did not approach it from that angle, but that's always been the procedure that I've been aware of. Why wasn't that done here?
Justice LaBarga, I went through that transcript again, and there is no mention of did anybody ask to perpetuate the testimony via deposition, and I believe it may be attributable to the fact that there was no, it may be attributable to the fact that the testimony had already been given, and so there was no need to perpetuate it. As a matter of fact, the state originally had objected or had filed a motion limine with respect to some of the questions that defense had asked at a deposition of this particular witness, and withdrew that and said, you let her testimony in, whatever questions you want from that, but it does certainly qualify as former testimony. And the trial court made several findings. They found same party, identical issue. The witness voluntarily appeared. This is not a witness that's hiding out, certainly. She intended to appear except for her medical condition, that she met the criteria for unavailability, and the defense did have a prior opportunity to cross-examine. So it came in as a former testimony, a firmly rooted hearsay exception. It was admissible under this court's decisions in Murray, Henry, and Muehlman.
If you're going to follow that procedure in criminal cases, I don't know of a criminal case that went to trial where at least one police officer wasn't on vacation. It just happens every time. So that would mean that the deposition testimony of the officer will be permitted to come in and be read to the jury in a criminal case.
Your Honor, I think because of this, because it met the unavailability by then existing medical condition, but as Justice Quince noted earlier, even if the court were to incline to say, well, you know, maybe they should not have done it this way, maybe that there's some kind of error, it's clearly harmless. And why is it harmless?
Well, let's just go back to the procedure, because
certainly.
Is there a difference between if something's taken in a deposition in a case, or if it is former testimony in another trial? Does the 90.804 make a distinction between what has to be shown?
Well, it's your former testimony, and this is certainly your former testimony. Certainly, sometimes depositions are footloose, and if they don't know that they're to perpetuate testimony, then the defense is going to be jumping through all kinds of hoops. They know that was not the purpose of it. We did not know that was the testimony that we were going to have to live with. So, did it have to be done here? No. Did the defense ask for it to be done here? No. The state was relying on the former testimony presented at trial, and the trial court went through the requirements of 9804. And so for the defense to suggest somehow that alternative that was never suggested to the trial court below should have been used, and I don't see the defense actually suggesting that, but were they to suggest that now, we would say no, that's certainly a procedurally barred argument, but where the testimony is at trial, and so you have the opportunity to cross-examine the witness. It's the same counsel, as a matter of fact, who did cross-examine the witnesses, and the state withdrew their objection to some of the questions that were asked with respect to a deposition, said you can bring those in too.
I think the important part about former testimony versus deposition testimony is that with former testimony, you basically have the same motive in your cross-examination to bring out information versus what you might be exploring in a deposition.
Thank you, Your Honors. I so inartfully tried to convey and I was unable to. Yes, exactly. Thank you. Certainly the motive for that. But if I could just highlight...
Well, and the point is that there was a full opportunity that the defendant had to confront that witness.
Exactly, Your Honor.
I mean, there's no suggestion that somehow that was inadequate. It was in the trial.
They wanted her to drive 3,000 miles, I guess, for over 3 days when she couldn't fly, you know. The real, and so you say, well, is that something that you would have to be doing? And Justice Parenti's questions earlier, I think, addressed that.
But
and
if
said
it
certainly.
was, let's just say, because since we have to carry this through, let's say the judge erred in finding her unavailable, although frankly, I'm not sure how that would have happened. But is it a per se reversible error under this rule, or do they have to show some harm?
No, Your Honor, it's not a per se reversible error.
Or
It is a discretionary ruling on the trial court.
But what I'm saying, if the trial court erred in abused its discretion, then what's the standard? Is it a per se reversal then, or do they have to demonstrate a Sixth Amendment violation in some way, questions they would have asked that they didn't ask, something else, or not?
You can never show a Sixth Amendment violation because there was the opportunity for cross-examination.
Okay. Well, what's the standard? Is it harmless error or per se reversal?
If it's harmless error, then you look at it under DiGilio and see if there was error in letting him come in. How important.
If it is. I'm asking which is the standard? Okay, you said it's.
If it's error, was it harmless?
That's the standard, not per se reversal.
Correct, Your Honor.
And that's based on case law that we've decided?
The defense has not cited any per se reversible error. They have just cited that the trial court abused its discretion. And so, hand in hand with an abuse of discretion. May I finish my one thought, Your Honor? I see my red light is on.
Please,
just
yes,
respect
yes.
to the harmless on the testimony of Suzanne Ullery. She tested the carpet, she tested the hairs. Her testimony with respect to the carpet and the blood typing was cumulative to Brian Higgins. Now, Higgins did not test the carpet. He did test the blood on the walls and link it to Joe Shan's profile. With respect to the hair in her left hand, that Parton's DNA matched. The Ullery testimony was consistent with Higgins' testimony as to the match and the Weiss testimony, Sean Weiss. Thank you, Your Honors. I would ask that you affirm the judgment and sentence. Thank you for the opportunity, and I appreciate you letting me go over time. Thank you.
Thank you.
Just have one point that I wanted to make with regard to the motion in limine pertaining to the fight that Parton was involved in. The appellee seems to be taking the position that this is relevant because it somehow shows that Parton had contact with the police but concealed himself. I don't see that anywhere in this part that he tried to conceal himself in any way. He didn't give a false name. He mentioned the fact that the police did not ask for his name. And true, he didn't run up to the police and say, "I'm Philip Parton, I'm wanted for murder," but he didn't do anything actively to conceal himself. Thank you very much.
All right, we thank you both for your arguments. We now move to the fourth and final case on today's docket. 140 Associates Limited versus Seacoast National Bank.
Good afternoon. May it please the court. Robert Sweetapple, Boca Raton, on behalf of the appellants.
Would you first address how we have jurisdiction in this case?
Yes, Your Honor. I think that what the Fourth District Court of Appeal has done is that it has effectively invalidated a Florida statute that was passed by the Florida legislature to regulate.
This would convey on this court jurisdiction any time that a lower court holds that a Florida statute is preempted then?
If I believe, Your Honor, that preemption, to the extent that it practically invalidates the law to a class of parties, that would be the case.
Do we have any cases where we have said that?
No, and there are no cases that say, and that have been cited by the appellee, that say that the court has to specifically say, I'm invalidating a state statute. If the effect of the ruling is to invalidate it,
I'm not so sure I agree with that, because as my understanding of our jurisprudence is that it cannot be an implied invalidation, that there must be a specific invalidation.
Well, this is an express invalidation. The court expressly stated that the Florida legislature...
Actually, let's don't spend a lot of time now. I understand what you're arguing.
Thank you. And really, the central...
But before we leave that, it didn't invalidate that statute per se. It said that that statute was not applicable to national banks.
That's correct. That portion of the statute. Now, what's particularly...
But let me go, if the alternative holding is, and let's say that if it is express preemption, that I don't know if we have case law on it, but that makes the statute invalid, but isn't an alternative reading of the statute is that it just doesn't apply to national banks, and if it just doesn't apply, then there certainly is no jurisdiction for us.
That argument is advanced by the appellee, and they make reference to the statute, saying other statutes are passed by the Florida legislature. If the intent of the Florida legislature was to defer to other code provisions or enactment of the federal government, I think that would be stated. So the reading that the appellee has given to that section of the statute, I don't think is correct.
But you're saying that national banks under Florida law are required to obtain a certificate of authority with the Department of State in order to operate. And if they don't obtain a certificate of authority, then they cannot operate in the state of Florida?
Not correct at all. That's not what I'm saying.
Then what is...
What I'm saying, Your Honor...
I thought the statute only had to do with whether they needed to get a certificate of authority.
They can clearly operate. In fact, when you understand the statute...
They just can't... what you're saying is they can't go into court. They can give loans, but then they can't go to court to enforce them.
Unless they defer to the Florida legislature's dictates on access to the courts of the state. This is what this case is about in a nutshell.
Well, effectively, though, they can't operate if they can't go to court to enforce obligations and their rights, can they?
Yes, and in fact, the law of the state has always been a duality.
Well, but the banking regulators think about that, a bank operating...
The control of the currency says nothing, and the Federal Bank Act says nothing about making loans, usury rates, repossessing property, access to courts.
Well, the Federal Bank Act does say that they can sue in any court, doesn't it?
No, it says...
As a natural person.
It says that, yes, it does, and that's the point I want to get to.
Taking them out of the corporate realm?
Right. That's a total fiction. Because the whole notion...
But that's the law of the United States.
Yeah, that's the law regarding every corporation in America. Every corporation in America. What's happened here, Your Honor, quite curiously is, in order to get around the dictates of the Florida legislature, which has said one thing and one thing only, if you want to come into the Florida courts as a corporation, either domestic or foreign, you must designate a registered agent to be served in this state. You must designate one, and you must pay a fee to have access to the courts as a plaintiff. They also say you have to register to do business, but then they say in subpart 5 that everything that you do as a corporation is ratified. So there's no, let's not pretend that Seacoast Bank hasn't been conducting itself for 50 years with any real impairment. They've just been conducting themselves for 50 years without paying what the legislature says they have to pay and using our courts day in and day out. Now here's the point. Here's the rub in this case.
How much do they, what is, just so, because we're talking about...
I believe it's $70
a year?
to register, and then $150 each year, and they designate.
And you think that's going to help the courts of the state to save off the more, I mean, in other words, you're making an interesting argument, and as far as what now you're saying what the legislature intended, and then the question is whether the National Banking Act says something else. But in terms of, I guess what isn't grabbing me here is that it seems like these certificate of authority are, you pay your $70, whatever it is, and then you get given that paper.
They're ministerial, Your Honor. And it's not for me to say whether or not the legislature is asking for enough money for their fees. The point I'm making is the legislature can determine what the filing fees are for a lawsuit. They can raise them tenfold. We've seen that.
Did this bank need to pay a filing fee?
Of course.
Okay. So you're making you were trying to make a compelling policy argument, and I'm simply finding some difficulty with accepting that this is a strong policy argument that the state of Florida felt that in order to allow banks or to use the courts of this state, that they needed to have the certificate of authority, as opposed to that they pay filing fees like everyone else, and they're not regular, and then the question goes back to, how does this conflict with, which is, I guess, why we're here, if we're here,
That's what I'd like
with
to
the
address.
National Banking
That's what I'd like to have
Act.
the opportunity to address if I could, and it's somewhat complex, and I am arguing for a paradigm shift in the way we look at these laws, and I think, if permitted, I'll be able to persuade you. First of all, let me point out to you...
Let me, and I will let you
Thank
go
you.
on with your argument,
Thank
but
you.
let me answer one question at the beginning. When you
Yes, sir.
talk about a paradigm shift, I want to make sure that I understand here. Have you cited us any case from anywhere that holds that a certificate of authority law such as this is not preempted by the
I have
Federal
not.
Bank Act?
I have
Okay, there
not.
is, so to your knowledge, there is no authority that would specifically support the position, directly support the position you're advocating.
And there's one Supreme Court case, I think, from Mississippi that's on this topic at all, and I'm going to show you quickly why Lima, Hibernia, and the Fourth District Court of Appeal are clearly in error. It's very simple. The Model Bank Act, what the court did is it seized on some express preemption. It pretended Congress controlled access to our courts. It doesn't. And when they realized they couldn't go there, they said, well, it says the power to sue and be sued is individuals. Therefore, they've morphed into individuals, so they can just walk into court as individuals. Frankly, Your Honor, with all due respect, that's utter nonsense. It's legal nonsense. The Florida Corporate Act, if you look at...
So but before you move to the Florida Act, that national act, what does that language mean then?
I'm going to tell you.
That says that a national bank can sue or be sued in any court. Just as an
It
individual.
says exactly what Justice Blatchford said. It says exactly what Abbott on Corporation says. We came to a point in corporate law where we recognized that corporations in the proceeding could make the same claims and have the same claims brought against them. It doesn't morph them into corporations. Florida statute 607...
Well, let me go back to, maybe, and this is a friendly question. I mean, they can sue or be sued, but nothing in the National Banking Association says that states can't charge filing fees when banks come into court, correct?
There's no mention of any courts. There's no mention of any registration.
So there's nothing...
And we've misconstrued this statement.
Well, let me help you out here. So
Okay,
your
please.
argument is there is nothing inconsistent about requiring a certificate of authority. There's nothing inconsistent with that, just like there's nothing inconsistent with a filing fee in terms of allowing banks to sue or be sued. It's no big hardship on a bank to have to register with the Secretary of State. Is that your argument?
Yes, that's one of my arguments. But more importantly...
So couldn't it have just been corrected in the course of the lawsuit then?
Absolutely. The court's closed. The court's closed. I can't waive that. No one can waive it. The legislature said, look, this is important.
But I thought they offered to get it a certificate
And they
of authority.
didn't. And the record's closed. They decided not to. But let me point you to something that's so telling. This is what Florida Statute 607 says about every corporation. 607-0302. They have the same rights to sue as an individual. The Not-for-Profit Act says same extent as natural persons. This has been adopted in all 50 states. Every corporation in the country has, since the mid-1800s, been recognized as having the power to sue and be sued, the same as an individual. How could the intent of Congress to use that language be to prevent registration when every state in this country's legislature has adopted that very language as the preface and intent to its registration of corporations? Corporations are registered in every state, and they all have the right to do business as natural persons and to sue and to be sued as natural persons. So when you read the very act that we litigate under, the courts are saying, oh, well, the Congress meant to make these corporations somehow special.
You said that Seacoast had been operating in Florida for 50 years?
No, they were operating since 1933, originally as a national bank, and then in the 50s they became a federal bank, and they just stopped paying. There was no precedent in the state.
But they continued to operate in this
Only
state.
in the state. without ever, in a stealth-like manner, never showing who their registered agent was in the repository of the state.
When you say a stealth-like manner, I mean, I don't know this bank, do they have one branch?
They have numerous branches, but we don't know who their registered agent is.
Well, since you were sued, your clients were sued, they didn't pay their loans.
We were the defendant in that case, but
just make sure we're in the right lawsuit here.
Yes, Your Honor.
You weren't trying to sue these banks. Your clients were trying to avoid paying legitimate loans that they had taken out from the bank.
Absolutely, but that's not my point. My point is the policy argument we got to before. Perhaps the Florida legislature said to these corporate entities, look, you're welcome as a foreign corporation.
It's just that when you use words like stealth operation, I think that that's my concern is maybe you can use less colorful language to just give what you're saying is that requiring a certificate of authority does not conflict with the power to sue and be sued.
I'm saying much more than that. I'm saying that if you are a national bank in Nebraska and you were doing business in Florida, that the legislature has said, you can come into our courts as a plaintiff, but first you have to tell the citizens of this state where you're located, who are your officers. We need a registered agent in this state so that you can be sued and served in this state. You cannot operate in Nebraska or North Dakota and come in here and not put this information on Sunbiz.
But if you were trying to sue them, I could see this being a problem. But since you're being sued and since they paid their filing fee and since they're a duly authorized bank, where's the impact? Why would a case have to be dismissed? That's maybe it's the remedy then that is that I question. That maybe the 4th District wasn't completely right, but the remedy didn't in this case, where you're the one that is being sued, doesn't seem to have any relationship to the certificate of authority that you're saying was so critical that they obtained.
Because the Florida legislature has said unequivocally, and they're the only ones that have the right to dictate what happens with our courts, they have said a foreign corporation transacting business in the state
I would
without a
disagree with that
certificate may not maintain a proceeding. And that's not for this court to alter. That's not for me to alter. That's not for the United States Congress to alter. The issue in this case is, does the Florida legislature have the right to control the access to the Florida courts by state and foreign corporations?
I thought that your basic proposition is correct. I mean, I thought this whole case was about whether the federal statutory scheme preempted that.
And they say that expressly does.
It's not a dispute about what Florida law says, because I think all of us have to agree with you. It's there in the statute. How does it apply, however, when you have a federal statute in this situation? So that's where I think you need to go.
Well, that's where I'm going. Where I'm going is twofold. Once, there's no express preemption.
You're going there in your rebuttal time. You may do that, but I just wanted you to know you're now down to a total.
Thank you. I will go there in my rebuttal time. Thank you.
May it please the court, my name is Jack Pelzer, here today representing Seacoast National Bank. With me is Rick Kupfer representing TJCV. Mr. Kupfer will be addressing the alternative grounds for affirmance, and I'll be addressing the preemption arguments. But before getting to that, I'd like to get to the jurisdictional issue that Justice Lewis brought up, and that is that there is no declaration of invalidity within the four corners of the 4th District Court of Appeal opinion.
Was there a motion to dismiss filed?
Yes, there was, Your Honor.
And did we deny that? Or
yes, it was. It was denied, Your Honor. Okay. But we raised it again in the briefs on the merits, and not with disrespect to this court's prior opinion, or prior ruling, but we viewed that as being a preliminary ruling on that issue.
Yeah, we have been known to revisit such rulings.
Yes, Your Honor.
But by saying that this statute is inapplicable to national banks, that's in essence what the 4th District said, correct?
That's correct, Your Honor.
And so is that at least a partial declaration of invalidity?
No, Your Honor, it's not. Counsel said, and I think I wrote his words down exactly, is that this effectively invalidates that portion of the statute. But the rules in this court's jurisdiction does not depend upon an effective invalidation. It depends on the declaration that a statute is invalid. There is no such declaration within the four corners of this opinion. For that reason, I would suggest this court does lack jurisdiction, and for that reason
Well,
alone.
one of the reasons for the motion to dismiss is you said it was moot because the property had been foreclosed upon and sold at auction about 2 years ago.
That's right, Your Honor. It was prior to the completion of the appeal.
Is it, think that it's going to be interesting as far as when this issue of invalidity and whether it applies to preemption. But let's go with the reasoning of the Fourth District. Tell me why it's not correct that if the power to sue or be sued is the statement, we all agree that the state can require, in order to condition access to courts on everyone paying filing fees.
Absolutely.
And doesn't interfere with the power. So that the National Banking Act doesn't say they can come into court without paying filing fees, correct?
That's absolutely right. Any fee that the legislature chooses to impose on a natural person can also be imposed on a national bank.
So where's the problem, and the policy problem, in terms of conflict with the National Banking Act, in requiring the certificate of authority, in requiring a resident agent? Certainly we now have banks that are, they're not always the good guys. They've been, some are doing things that have been called into question, and we ought to have a place where someone can look to say, here's who's registered to do business in this state, here's their resident agent, and I'm going to sue them. We're talking about, if this is correct, $70, $100 a year. I am sure your bank does quite in excess of that. So I'm not seeing where the conflict is.
Well, you're
conflict with the federal law.
Okay. I will not try to convince this court today that these fees are insurmountable or pose an impenetrable burden to my client to come into court.
Are they in the hundreds, or are they in hundreds of thousands?
Well, if we get into past penalties, I think it would, going back as long as Seacoast has been around, it could get up pretty high. The state isn't trying to get money from you, no,
right?
It isn't. No.
So the only issue is whether that statute, which requires, it seems on its face, requires you to obtain a certificate of authority and designate a resident agent, is in conflict with the federal statute that says that you have the power to sue and be sued.
Precisely, Your Honor.
How is it?
Well, it's in conflict because it adds additional burdens.
But how much more of a burden is it than filing, we raise the filing fees on mortgage foreclosures. We require mediation. That's all, and banks are filing hundreds of thousands of foreclosures in this state.
And all those filing fees apply to natural persons just as much as they do to national banks. It's the discrepancy between the treatment between a national bank and a natural person that is the critical distinction here, not whether the courts have the right to, or Florida has a right to charge filing fees.
What shows in the federal law that they would not, that it is in conflict that a bank has to register just like any other corporation that is going to go into court?
Because it says as fully as natural persons, and anything that detracts from as fully as natural persons is an alteration of that scheme and goes against Congress's intent. Congress has specifically described how national banks are to be treated in state court systems, and that is as fully as natural persons. Anything that deviates from that is expressly preempted by 24 subsection 4.
Well, how does someone sue a bank that hasn't registered? Where do you go sue them?
How do you serve them?
Yes.
Normally, they serve an officer at a branch. That's the common practice.
And is that what goes on in actuality? I mean, if this bank has been here for over 50 years, certainly there must have been some kind of litigation with Seacoast before now.
Oh, absolutely.
And they are served at whatever branch the person may have gotten their loan from,
or any other branch. That's very common, Your Honor. The process server just comes into the branch, asks for a manager, and hands on the papers.
And you don't go into court and say, you didn't serve my resident agent, so you should be thrown out of court?
No, Your Honor.
Okay, so is there any evidence, one way or another, that the Florida legislature intended to include or exclude banks from the requirement of a certificate of authority?
Well, frankly, Your Honor, since this is the Model Business Corporation Act, which is uniform through, I believe it's all 50 states now, many of which have considered this question and reached the exact same conclusion, it probably wasn't within the Florida legislature's particular contemplation at all. And in fact, it's because that's exactly why we have the usual rule. If these were two state statutes, we would have a specific statute that would control over a general one. But in fact, here we have not two state statutes. One is an act of Congress, which has the supremacy.
So under the National Business Act that's enacted, are you saying that it's in conflict or it just doesn't apply to banks?
Well, some courts have taken the position that it simply didn't apply. The legislatures didn't mean that.
Under that circumstance, if it doesn't appay, then there's no jurisdiction at all under that situation.
That's right, Your Honor. Now, of course, the Fourth District here did say that it is expressly preempted, and it is inconsistent, and I think this is the reason why the Fourth District said that, and I think they're quite right. It is inconsistent to say that Congress intended national banks to be treated as natural persons and as fully as natural persons, and at the same time impose additional requirements on them that are not required of natural persons, and that is an express conflict. You could also say that this is an implied conflict, and this is the principal criticism that my colleague, Mr. Sweetapple, levels against all the other cases against him, is that they don't do sufficient analysis or sufficiently label the exact preemption theory that they're using. I would say that the Supreme Court of Mississippi was right when they said the reason why the analysis is short is because the answer is clear, that there is this intended preemption. But if we get to a conflict implied preemption, there's also that implied preemption, excuse me, because the Bank of America versus Lima case, the Hibernia case, have all said that it is repugnant to the National Banking Act and its requirement that national banks be treated as natural persons to impose additional requirements. Therefore, there is that implied conflict. And the recent case, last month, the 11th Circuit decided the Baptista versus J.P. Morgan case that I provided as supplemental authority last week. In that case, the court expressly applied an implied conflict preemption analysis to a state regulation of a national bank and concluded that it was not a right to sue and be sued, but it found that it was impliedly preempted under the conflict analysis. In that case, the state purported to preclude a national bank from charging a non-depositor a fee for cashing a bank's check. The Office of the Comptroller of the Currency specifically authorized that. Now, the court found, and this gets to your other question, Justice Periente, that it was possible for the bank to comply with both, because the Office of the Comptroller of the Currency didn't require the charging of the fee, it merely permitted it. But the 11th Circuit decided that by decreasing the bank's options in that circumstance, that created conflict preemption. And for that reason, they said that the state statute that precluded the charging of the fee was preempted on an applied conflict preemption analysis. And we could even find that this is a field preemption, and this gets to the Cox versus Reconstruct Bank, where the court found that the federal regulation and governance of the power of national banks to sue and be sued was so complete that it actually created federal question jurisdiction for removal purposes in a case where there had been actually no federal claim pled at all. So you could even say under that analysis that there is even field preemption in this case. On the other points, I'd like to rely on the brief and yield the remainder of the time to my colleague.
May it please the court, Rick Kupfer representing the Florida Land Trust, which stands in the same position as Seacoast National Bank, and naturally I agree with everything that Mr. Pelzer just said. I'm not going to repeat anything he said, but there is one point I'd like to make on the federal preemption issue before I move on to a separate issue that only affects my client. There is a separate statute, Florida statute, in the Florida's Business Corporation Act. It's section 607.0301. It provides that the General Corporation Act in Florida applies to all corporations except when other special statutes are meant to control certain types of business and they're in conflict, then the Florida statute expressly defers to the other special statute. The National Banking Act is that type of a special statute, which is in conflict because of this requirement that for access to courts, no state can regulate, can deny access to the courts by requiring a national banking association to first be licensed at the state level and pay an annual filing fee, which is in essence a tax to the state of Florida. So you really don't even need to rely on express federal preemption principles because Florida's statute expressly defers back again to the federal act.
What's the site on that?
The site on that is section 607.0301.
Now, what did the I don't recall that.
Fourth District didn't mention it. We did argue it in the brief. The Fourth District did not pick up on that statute.
Sounds like a pretty good argument.
So, well, that's why I tried to squeeze it in. Having done that, I want to move instead.
It must not be that good, though. There must be some reason.
I want to move to a separate procedural issue that we've raised before the Fourth DCA, and the Fourth DCA also didn't speak to this issue. There's an alternative procedural reason to affirm here because this entire defense that they're raising, that the bank wasn't qualified to do business in Florida and never obtained the certificate of authority, that was never raised in any initial pleading. It was never raised in any amended pleading. It was never raised as an affirmative defense. When it was raised in response to the bank's motion for summary judgment. It was raised in the very last document that was filed in the case just before the summary judgment hearing. And we did, at the summary judgment hearing, we mentioned the fact, the bank's attorney mentioned the fact that this is an 11th hour defense which is suddenly coming out of nowhere. This court's rule of procedure, 1.120, and the cases that are decided under it, which we've cited in our brief at page 19, provide that whenever a party wishes to challenge the legal capacity of another party to either sue or be sued in state courts, it has to be raised in the pleadings, either initially in a motion to dismiss the complaint or as an affirmative defense, or else it's waived. Now, Mr. Sweetapple has responded to that, and he has said, well, we're raising a defense, though, that goes to the subject matter jurisdiction of the circuit court, and we're allowed to raise that any time. That's incorrect. This is not an issue. This has no impact at all on the circuit court's subject matter jurisdiction. We're talking about a Florida statute that creates a legal disability on the part of any non-compliant foreign corporation that does not register with the state, with the Department of State. It doesn't impact the court's jurisdiction. The circuit court, it's a personal disability on behalf of the corporation that's non-compliant. In fact, the statute even says that the circuit court can stay the case until a foreign corporation obtains the proper licensing. If the court didn't have subject matter jurisdiction to begin with, it can't stay the case. It can do nothing but dismiss it for lack of subject matter jurisdiction.
So you're saying that if they had raised it through motion to dismiss, the bank could have moved, and it was something where it was a corporation and a bank, and they go, oops, our certificate of authority elapsed, we didn't realize it, or whatever.
There would have been time to act.
All you had to do was go.
The first chance we had to even respond to this argument at all, because of when it was raised, was right at the summary judgment hearing itself. And there was a statement made by the bank's attorney that, well, we can go out and get it, but there was no, at that point, there was no time to get it. The circuit judge did ask the parties, because this was something brand new that was being argued, and he asked the parties to submit supplemental briefing to the court on this new issue that had just come around. And the courts, and we submitted supplemental briefing. But I would suggest that even if you disagree with the Fourth DCA in the way that it decided the federal preemption issue, there's still an alternative reason to uphold the summary judgment. So we would ask this court to approve the Fourth District's decision, whether it's based on the reasoning used by the Fourth District or an alternative reason which leads to the same end result.
Let me ask you, is it your position, though, that we don't have jurisdiction? Or do you?
It is. It was my position when I filed that motion to dismiss.
Still is, right?
And it still is. The constitutional, I'm sorry.
are there any other circumstances? Certainly, the filing to procure a certificate of authority is I mean, it's well known, it's been established for years, and it applies in numerous kinds of settings. Have the Florida courts never addressed that issue in any context, anywhere with regard to national banks?
We haven't been, I don't think either party has found any
Because
Florida.
it's not like this is something new.
No,
this
no.
has been there forever.
It's been there forever,
and numerous
and
reasons other than lawsuits, correct?
Yes, and I don't. I commend Mr. Sweetapple for thinking outside the box here.
But you're saying he thought outside the box a little too late.
A little too late.
And too far.
Too far, right. But because, again, I'm looking at 1502, and it says specifically that the court can stay a proceeding until they determine whether the foreign corporation is required to have the certificate, and if they are, until they obtain it.
Correct.
Which seems to show, I'm just sort of, as I look at that, it just even seems more apparent that this is nothing, this is really not of consequence for proceedings in courts of law, that we should, that even if it were in conflict with even if it wasn't in conflict, there was an easy remedy for this bank, I guess, which was to
There was an
obtain
easy
it.
remedy.
Although they don't want to.
If the issue had been timely raised.
If the issue had been timely raised, and if we were talking about implied preemption, then that would be a criteria as far as how difficult is it to
But they don't want to do
comply.
this because apparently they're worried somebody's going to come after them for 50 years of back fees or penalties or
Not
something.
only that, but there's a lot of national banks in Florida that are similarly situated. As far as I know, every one of them. And so if this court were to be the first one in 150 years of the National Banking Act to hold that national banks have got to comply with local registration and licensing requirements, it would have reverberations throughout the country.
Well, I guess we would certainly get that one up to the United States Supreme Court, huh?
Yes, don't do that. Thank you.
Thank you. First of all, the keys to the circuit court are in the hands of the legislature.
Yeah, can you address 607.030?
Yes, 01. Except that special statutes for regulation and control of types of business and corporations shall control when in conflict herewith. First of all, that's a reference to Florida statutes. Second of all, there's nothing in conflict. The National Bank Act.
How do we know that that's just in reference to Florida statutes?
Well, because it refers to statutes.
Well, the United States has statutes.
Okay. Well, the bank, don't then abandon that argument, okay? There's nothing in the National Bank Act that's in conflict. The National Bank Act has always recognized a duality, and there's no dispute that contracts, debt collection, torts, criminal law, zoning, acquisition of property, access to courts have always been administered by Florida.
I guess what his argument, which I found, tell me this, he said that, no, that the National Banking Act says that you must treat banks no differently than individuals.
It doesn't. It says, this argument that the 4th District has uttered and issued will destroy the entire Corporate Banking Act. Now, if to sue and be sued as a natural person means that you're an individual and you don't have to register, then let's go tell all the Florida corporations and all of the foreign corporations.
We're just talking about national banks here. We're not talking about every foreign corporation.
Well, it's the same language. It's the exact same language. The Florida statutes.
We don't know that it's the exact same language. What we have here is a National Bank Act that uses that language. So we're really talking about national banks, whether they are preempted, not every foreign corporation that does business in Florida.
With all due respect, the Florida legislature in Florida Statute 607-0302 has said that all Florida corporations can sue the same as individuals. In the not-for-profit statute, they say to the same extent as
all Florida corporations can?
All Florida corporations. Okay. And they say that all not-for-profit can sue the same as natural persons. This language is not some language that the Congress originated for national banks. So if national banks are individuals, have morphed into individuals because of this language, every Florida corporation is now an individual. Then no one has to register. So there's nothing in the National Bank Act that even pretends to discuss the issue of access to courts being special for these corporations. The federal government could have set up a system of federal court jurisprudence. These federal banks are coming into our courts, using our courts, and our legislature is uniformly dictating to all foreign corporations. No doubt they're foreign, no doubt they're doing business.
So is your argument that that language that we've all been talking about from the National Bank Act has no meaning?
No, it means exactly what Justice Platchford and what Abbott on corporations said. It doesn't morph you into an individual. It means when you're in the proceeding, you have the same rights and the same defenses.
To get rid of that historical prejudice against corporate entities, and that was been put in.
Right.
I don't mean how many, whether it's 100 years ago, but it's probably 70 to 100 years ago.
And let's keep in mind, this is not a situation where I could stipulate with the bank, pay me 10 years worth of your filing fees, and even though Judge Cook knows you haven't complied with the statute, let's give him an agreed order that he can hear this. It's not persuasive to pretend that I can stipulate that I could waive this. The legislature has said, this is important to us.
But it does seem to me that there is, in allowing the judge to stay it, that if the legislature, if the Department of State thought banks should be covered, it's really up to them to worry about collecting, fining and penalizing, not for the courts, because it's not impacting the courts, because the money is, they're still paying filing fees just like everybody else is.
I think that's correct, and I think the legislature has. First of all, there's a statute of limitations.
I just don't see how there's any why you didn't waive it by not filing as a motion to dismiss. What about that argument?
Because this is a huge red light. What the legislature said is, Judge, when you learn that this corporation hasn't paid, the courthouse is closed, no action can be maintained. Stop it. Do an inquiry. Find out whether or not they are doing business. Answer yes.
Let me make sure I understand the full scope of what you're suggesting. Are you suggesting that because the court lacked jurisdiction, that essentially any judgment entered in favor of a national bank that did not have the certificate of authority would be a void judgment?
No, I'm not.
Well, it sounded like that's what you were suggesting.
Well, because of a rule of vesting this court's well familiar with, this would affect vested rights. This opinion would only have prospective effect because of the fact that it does affect vested rights. But clearly, I don't think there's any doubt that any judge who entered a judgment when the legislature told him not to proceed in favor of a national bank that admitted it was doing business and wasn't registered, acted without authority. He was told the action could not be maintained. I cannot stipulate to have him do that. And I don't believe that even the United States Congress can tell the legislature that they can't do this. And then we get into implied preemption. The standard for implied preemption, which is everything and subject matter jurisdiction would be void. Yes, the court shouldn't. There was a big red light. Stop. Hold an inquiry.
You're saying
and now
void.
There's a red light on down here, but I'll give you another minute to sum up.
Thank you very much. With regard to implied preemption, which is everything else they've now run to, even though they say that's not what was at the court before, no record of any substantial impairment at all. They didn't put on any record of that. There is no substantial impairment. In the Cox case, that dealt with an opinion by the court that somehow the state might not give the certificate. This is a ministerial act. It's just a registration. And the standard is clear that any implied preemption has to be a substantial impairment. There's no substantial impairment. These fees and this form is a fraction of one filing fee and less questions than a civil cover sheet. And it's for a valid public purpose. But these cases you see are wrongly decided when they misconstrue sue and be sued. They're wrongly decided when out of thin air courts find some substantial impairment. They just don't exist. This court should give deference to the Florida legislature, and this court should allow the Florida legislature to continue to protect and determine the terms of access to our courts, and no one else, as long as they comply with the Florida Constitution and the United States Constitution. Thank you for hearing me. It's been a pleasure.
Thank you. We thank both sides for your argument. That being the final case on today's docket, court will now be adjourned. All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.